Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons have business with the Appellate Division. Going here, give your attendance, you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, November 18. Please ask for the time that you actually need in order to get out the salient points of your arguments. Keep in mind, we have read your briefs. We are fully familiar with those arguments. People v. Luis Lopez. That matter is submitted. State of New York Unified Court System v. Civil Service Employees Association. Five, 2, and 5. I'm sorry, were you asking for rebuttal or no? Were you asking for rebuttal, just, okay. So that's 5 and 5. Matter of Angelica? Do we have a respondent? Did you still wish to argue? Certainly, 3 minutes. Crespo v. Francini? Two, 1, and 2. Smith v. Caban? 5, 2, 5. People v. Rodney Sanders? That matter is submitted. People v. Brandon Smith? That matter is submitted. Gelwin versus D. Ratafia? Yes, I understood that the appellant was running late, but is everybody here now? Okay, so as I stated, the appellant petitioner is running late, so we'll do 5 and 5, and when he gets here, he or she gets here, we'll see what's going on. Irizarry v. Zalea? Five and 2, 5 and 5. Justice Pitt Burke is recused on that matter. People v. Mitchell Howell? That matter is submitted. Kim v. XP Securities? Everything's going to be argued together. Respondent? Certainly. 5, 2, and 5. 902 Associates v. Union Square 902? 5, 2, 5. Sanibel Trading? 6, 2, 6. People v. Christian Saunders?
I will request 3 and 2, please.
3, 2, 3. U.S. Bank v. Kiki, excuse me. We'd be happy to have it submitted as well. The matter is submitted. People v. Dashin Simmons? That matter is submitted. People v. Mark White? 5, 2, 5. Domageni, I apologize for the mispronunciation, v. Corpen, LLC. Yentis v. Yentis, I'm sorry, 5 and 2 and 5. Yentis v. Yentis, that matter is submitted. Justice Gesmer is recused on that matter. First case for argument is the State of New York Unified Court System versus Civil Service Employees Association. Yes, whenever you're ready.
Good afternoon, may it please the court. Aaron Kaplan appearing for Darren J. Rylowitz, Civil Service Employees Association, representing the respondent appellant. CSEA is not seeking through the grievance or arbitration procedure restoration of Mr. Grancelli's title or grade, only for his salary to remain at the level he was receiving before January 28th, 2023, when his title was changed and his salary reduced. And even then, only until such time as the title of associate court attorney reaches the salary he was holding.
So is the unified court system claiming that that was some type of an administrative error?
The UCS is claiming that it was an administrative error. That is CSEA's position, that that issue is for an arbitrator to decide. Administrative error could be the case if evidence was provided by UCS that a change in the title occurred before Mr. Grancelli was appointed, and he was, by error, appointed to the incorrect title. Here, evidence put before the court is that Mr. Grancelli's predecessor was in the title of principal law clerk to judge. And it was only after Mr. Grancelli was appointed that the title was changed, a little over a year after he was appointed.
As to the predecessor, how long was that predecessor functioning as a principal law clerk?
I don't believe, I'm sorry, I do not have that answer for you.
The initial grievance filed was for title, grade, and salary, and that now you're saying is just what?
Correct. CSEA is only seeking to bring forth the salary issue before the arbitrator. This court in Zacharel v. Manios, which is in UCS's brief in this case, held that if the relief requested by the grievant or in the grievance is broader than the arbitrator has the power to provide or to award, that the arbitration should still go forward. And if the arbitrator exceeds his authority or if his decision then violates public policy, the party so aggrieved would then move to vacate. So any stay of arbitration here would be preemptive.
So as to procedure, 15.7 of the CBA reserves authority to the arbitrator to make rulings as to issues of arbitrability, yes?
Yes, it does, Your Honor. The arbitrator, the parties reserved arbitration as a preliminary issue. So the way it is written is that the issue of arbitrability would be bifurcated to be put before the arbitrator, and the arbitrator would issue a decision on arbitrability before the parties would present the case on the merits to the arbitrator.
So basically your grievance or the issue is whether or not the unified court system had the authority to reclassify, which resulted in, whether the unified court system had the authority to reduce the salary, which would be in violation of the collective bargaining agreement.
Yes, Judge. The claim is that the collective bargaining agreement, specifically Section 20.2 and possibly also 19B, restricts the court system from diminishing salary when a position is reclassified. And it is CSEA's position that because the change in title occurred after Mr. Grancelli was appointed, that is a reclassification and his salary could not be diminished. Again, that does not mean that his salary, he will continue to receive the salary of principal law clerk to judge throughout his career. He would only continue to receive the same salary with no increases until the associate court attorney position reaches that same salary level, which we believe occurred April 1st, 2024. So because of that, we're only looking at approximately a $4,400 difference of opinion, essentially.
Well, sir, how do you answer OCA's position that redesignation of Mr. Grancelli's job title concerns the application of the rules of the chief judge, not a contractual term of the CBA.
Well, UCS uses a term redesignation, which does not exist in civil service law or any rules. That, I believe, is their way of saying that they made an administrative error, so they are changing the title instead of a reclassification. Again, I believe that is an issue for the arbitrator to decide, whether or not the change occurred before Mr. Grancelli was appointed, and by error, he was placed in the incorrect title, or whether the position he held was principal law clerk to judge when he was appointed, and then thereafter, the title was changed.
You
Titles,
have time on rebuttal. Thank you.
thank you.
Good afternoon. May it please the court. Pedro Morales from OCA Counsel's Office. We represent the Unified Court System.
So, counsel, you would agree that redesignation doesn't appear anywhere inside the CBA?
It does not appear inside the CBA.
And
but
you would also agree that there is protection for the employees in terms of salary inside the CBA?
Under certain circumstances, that is correct. However, that is
Under
not,
Article 20?
No, Your Honor. There is a provision in there that does protect the salary of an incumbent in a title that's been reclassified. The prohibition is that the salary not be reduced as a result of that reclassification. However, in this particular case, there was no reclassification. Reclassification entails a change in the duties and responsibilities of a position that applies statewide. It is not just applying to a particular position. What happened here is that Mr. Grancelli's position was redesignated. It was discovered as a result of an administrative error that he had been placed in the principal law clerk to judge title.
I'm sorry, what is the difference between reclassification and redesignation when you're talking about the diminishment of the salary?
The redesignation is simply a correction. It's another word for correction. The chief administrative judge, acting on behalf of the chief judge, has the authority, as already been noted, to classify the titles of the Unified Court System. That includes correcting errors where an employee has been placed in the wrong title.
So, counsel, I would assume that the posting for the vacancy described the title as principal law clerk, right?
It may very well have been, and that would have been an error because the position that this Mr. Grancelli was serving did not qualify for placement in that title.
here's the
Went into?
Excuse me, the
position that
the
the
position he
person-
was appointed to, the original principal law clerk judge position, he was appointed to that position, but that was an error.
That was a vacancy. That's what I don't understand. That was a vacancy. He was now in that position based upon a vacancy. The individual who held that position prior to him with the same duties and responsibilities was designated as the principal law clerk, right?
And that was probably an error as well. They only caught it.
That was an error as well.
probably
Did
was
you go
an error as
after
well.
that individual as well to recoup any monies?
No, Your Honor.
And that individual, who was that individual who held the position
I
prior
don't
to?
recall the name of the individual, but I will say this.
Was he a judge, he or she?
The person who served as the principal law clerk,
A retired
A
judge.
retired judge?
I don't recall, but going back to your
Well, I think
question,
according to the record, he might have been a retired judge.
I don't know if that's the case.
don't
But
know.
The fact of the matter is that the state finance law prevents a person.
How long did Mr. Grancelli hold this position before it was determined that it was an error?
I'm not sure I know that information.
How long did the individual who held it before Mr. Grancelli, how long did he
That
or
I don't-
she hold that?
That I don't know, Your Honor.
We don't. So we don't know how long this error transpired, right?
Right, that's correct,
Right.
yes.
Okay.
And as to arbitration, what is the problem with sending this to arbitration to A, determine whether this is a matter that should be arbitrated, and B, to determine whether Section 20.2 of the collective bargaining agreement applies, which says that no reduction in salary shall take place because of reclassification? What is the problem with sending this to arbitration if UCS signed off on this?
What the problem is that you're asking, it violates the public policy against
What public policy?
The public policy is that there can be no arbitration of matters that concerns the sovereign function of the state. And here,
So in 1999, the Court of Appeals held in Watertown that an anti-arbitral presumption is no longer justified either in the law or in the public sector with respect to labor. The merits of the grievance in that case were not the court's concern. Why?
that has changed, Your Honor. There is still the rule against arbitrating matters that affect the sovereign function of the state. That has been upheld in other cases. We have cited in our brief. So
How does this challenge the sovereign function of the state?
the sovereign function of the state is the ability to select or develop the job titles of the court personnel who are responsible.
But the challenge is not to the unified court system's authority to classify, reclassify, allocate, or reallocate. It's to determine whether or not there's a violation of the collective bargaining agreement based upon the fact that there was a diminishment of salary.
Part of the authority to classify and reclassify the job titles of the unified court system entails making sure that that persons are properly in those titles. It is, in fact, to enforce the job title.
So under that theory, then, any diminishment of salary under a individual covered under the collective bargaining agreement would not be subject to arbitration.
That's correct, Your Honor.
Thank you.
Thank you, Your Honor.
Matter of Angelica.
Good afternoon, Your Honors. May it please the Court, the Children's Law Center by Laura Selecki, attorney for the appellant child, who will be 17 years old in February. In my appellant's brief on behalf of the child, I argue that the family court applied the incorrect standard when determining the mother's petition, that this court should nonetheless find that extraordinary circumstances exist, and that it should reverse the order below.
So we would have to make that determination, or we would have to remand?
My position at this time is that the court should remand the case regardless of whether it finds the record sufficient to find extraordinary circumstances, because the child's situation has changed so significantly since the entry of the order below.
But there was, given that the underlying custody order was entered into on consent, there was never a finding of extraordinary circumstances.
That's exactly correct, Your Honor.
So if we were to find that the record adequately shows extraordinary circumstances, would it be appropriate to remand it for the best interest question, on the best interest question, given the changes in the child's situation?
That's exactly my position at this time, Your Honor. My client has, undergone a ton of changes since this order was entered. She had been living primarily with her grandmother for much of her life. She's, went through the transition of living with her mother in a new school, a new community, a new home. Her position with respect to that order and with respect to this appeal has changed over time. So she initially was adamant about appealing. Then after we filed the appeal, she said she no longer wished to pursue it, and she has been ambivalent since that time. She also has raised concerning issues, including that she was psychiatrically hospitalized twice, and also—
So all of these issues, therefore, would require us to remand for further proceedings and a determination as to the issues.
Correct, Your Honor. My client is extremely emotionally torn, and this really just underscores the need for the family court to revisit it.
Thank you. Thank you very much.
Thank you.
Crespo v. Francini.
Good afternoon, Your Honors. Greg Friedman for the appellant, Dr. Frantini. So I had to address the substantive malpractice claims in my brief, right? But they really should not matter as far as Dr.
So
Frantini is
was the
concerned.
matter at some point dismissed as to Dr. Francini?
It was dismissed way back on procedural grounds. Plaintiff never took an appeal from it. So by the time we got to summary judgment, plaintiff for quite a while had not had any direct claims against him. there was just a third-party claim by the co-defendant, and when we moved for summary judgment, and I thank them for this, they openly supported us. They made the same exact arguments, and they do the same thing on appeal. So again, we can talk about plaintiff's claims and the problems with the opposition, but the fact is that it should be academic for us because there were no claims against Dr. Franchini by the time the summary judgment motions were decided. We cited a few cases. Patrick, Justice Gesmer, you were on that case. It was my case back in the day, and it's a pretty straightforward proposition in terms of abandoning claims, cross-claims, third-party claims, whatever have you. So we can get into the merits if we need to, or I'll save you some time, kind of rest on that primary procedural argument where whether Dr. Franchini met the standard of care or not, we say he did. I think there were some glaring holes in plaintiff's opposition, but it's really academic because he has to be out of the case either way.
So are you saying we should dismiss the appeal as abandoned or as something else?
Not the appeal would be dismissed, that the trial court essentially had no grounds to deny summary judgment to Dr. Franchini because nobody had a claim against him.
So we should reverse it on the grounds that it had already been determined that he was not in the case?
Well, exactly, because plaintiff didn't have any claims to begin with, so there's no direct liability. And the co-defendant openly supported us both below and now, so they no longer had a third-party claim. So his liability, if any, is academic because he can't be a party to the case anymore. And that's our main argument. It's supported by Patrick and at least one other case in our brief. It's at page 22. So I'm happy to answer questions substantively. If not, I'll rest on the brief.
Thank you.
Thank you.
Good afternoon, if it pleases the court. My name is Edward Nicholson. I'm with Chiavetti, Corrigan, Edwards, Weinberg, and Nicholson.
Could you address counsel's last argument that Dr. Franchini has not been in this case for some time?
Yes, and we are actually the co-defendant. Plaintiff's counsel, who put in opposition to the appeal at this point, told us earlier today that they were going to be submitting their papers.
Sorry, who do you represent?
I have Dr. DeBello and New York Foot Care. I was a prime defendant, and we got out on summary judgment. The only argument I was going to make to the court today is that I believe that the lower court erred in finding that there was a question of fact as to whether ostensible or apparent agency exists so that we would be vicariously liable for Dr. Franchini. I would also argue that Dr. Franchini, per his counsel, was properly dismissed earlier on in the case, and that there were no claims brought to him that should be active at the present time. Dr. Franchini was not an employee of Dr. DeBello or New York Foot Care.
You said he was an independent contractor?
Yes. We did not exercise any control, and then there's no evidence.
Is that clear from the record that you exercised no control over him in terms, I mean, he did work at the facility or use your facility, did he not?
Yes, but we had no indication. We didn't tell him how to perform the subject surgery. We didn't indicate or provide any type of control over how that surgery would be conducted or what type of post-operative or preoperative clearances or care would be required.
So here's a question. Did your client acknowledge at any point in time that Dr. Franchini did not deviate from the standard of
Yes, and we've
medical
argued
care?
that both on the summary judgment and then in our respondent's brief, we argued that Dr. Franchini did not deviate from the standard of care.
So is there any basis for the indemnification and contribution claims?
No, and that's why we did not pursue opposition to the underlying summary judgment motion.
Thank you. Thank you very much.
Thank you.
I know I'd reserved a minute for rebuttal. I'll probably take about 20 seconds. I just wanted to speak to your question on the agency vicarious liability. I don't think it matters really for us at this point, but I believe in the record plaintiff didn't even argue there was an issue as to control and fact. They said there's only an issue on ostensible or apparent agency, but if you look at their bill of particulars, it doesn't really set forth any facts alleging that. So going by the case law, the burden was just for us to show that Dr. Franchini was an independent contractor. Okay? Then plaintiff in opposition had to submit something to raise an issue of fact on apparent agency. he didn't do it. He didn't submit an affidavit. He didn't point to any testimony. He basically just said, well, we don't know what my client's state of mind was, so there's an issue of fact. The trial court bought into that. I think they had it backwards. It was his job to raise an issue of fact, and he didn't do it.
Thank you.
I'll rest on the brief. Thank you.
Smith v. Caban.
Good afternoon. May it please the court. Antonia Kasulas for the petitioner. Sergeant Smith was a sergeant for the police department for
Counsel.
nearly 12
Counsel, could you lower the mic so we can
for
hear you?
nearly 12 years with an unblemished record, a record of devotion to his community and service to his community. On June 28th, he was arrested as a result of an incident involving his then girlfriend. He was arrested. She
Yes, counsel, we're familiar with the
Yeah.
facts. So the
So-
issue becomes, one, was there substantial evidence to support the hearing officer's determination? And then whether or not the termination of your client shocks one's sense of fairness. So the first question, was there not substantial evidence in support of the hearing officers, in terms of the determination by the by NYPD?
I submit there was not, and there's two issues that I raised with that. First is the decision largely rests on sealed criminal court records.
Which apparently the attorney who represented your client at the time stipulated to. Not only did not object to their admission, but stipulated to the same.
I appreciate that, Your Honor, but the difference here is that there was a court order that was issued in the matter of.
So what was the hearing officer to do then? There's a stipulation by the attorney that those records, and we're talking about video, I think a videotape, I think photographs, other evidence. So what was the hearing officer to do then when there's a stipulation to the admission of those items? Was he or she not to consider those items?
Well, there's two issues. First, the police department, and we submit, engaged in misconduct here by even accessing those documents in violation of the
That may well be. My question is, again, the attorney for your client at the hearing stipulated, meaning consented to the admission of those items for consideration.
Right, but there was an injunction in place, and my client's counsel
Where's
at.
there evidence in the record of an injunction in place regarding the hearing officer's consideration of those records?
Well, the hearing officer is an employee of the police department, and that's another issue I had raised. He was hired as agency counsel. The department advocate, if anyone was aware of this injunction, it was the department advocate and the hearing officer, not private counsel. He may
Counsel, I'm
not
just
have been-
wondering, if there's a sealing order when coming from the criminal court, but then someone allows those documents that were supposedly sealed, I mean, the objection should have been made at that time that these items are sealed, they're not admissible, you shouldn't be relying on them. It's different that the objection, I mean, it's not even that, it's bad enough, rather, that the objection wasn't made, but then to stipulate and say, yes, you can still use these documents, I don't know where that leaves us for review.
Well, does that mean that the police department, which had a prosecutorial role here, can just go violate?
Well, that may well be, but at the time that there's a motion for the admission of the evidence, of the documents, et cetera, there should have been an objection. There should have been, well, these items were sealed, and therefore they should not be put before the hearing officer. As my colleague stated, not only was there no objection, there was a stipulation consenting to their admission.
Well, there was, but the issue here is in the interest of justice. I think this court can step in. I mean, and
So you're saying that
Counsel,
even if a party enters a stipulation, we should disregard it?
well, this was a clear violation of not only an injunction, but the law, the letter.
Counsel, the sealing of the record, it usually is to protect the defendant, right? That's one of the reasons why you seal records. So if you have what essentially is a waiver of the sealing of the record, why is that waiver signed by, entered into by the attorney for the defendant not viable?
Well, I appreciate that, but again, the argument goes back to, there was no motion by the police department to even access these records. The police department just had unfettered
Again,
access.
an
to
argument
these
that should have
documents.
probably been made prior to consenting to allowing them
Right.
be used.
I'll address the issue of the penalty on rebuttal since my time is up. Thank you.
Yes.
Good afternoon, Your Honors. Shane Magnetti for the respondents.
So counsel, what do we make of that? I mean, these were sealed records, right? We all know that maybe there should have been a motion made in order to unseal those records, or should there have been?
Well, these records were sealed, that's correct. But the fact of the matter is, counsel stipulated to the admission of all of the evidence that came in at this hearing. And this court has held in numerous cases, such as in Marks, Hossein, and Castillo, that it has no discretionary authority to review a petitioner's unpreserved challenges to the admission of sealed arrest records at a hearing. And that's exactly the case here. I would point out the Hossein case specifically, petitioner made the exact same argument that there was an injunction in place by virtue of the RC versus City of New York cases, and this court rejected that argument and determined that because it was unpreserved and because the records were nevertheless admitted on consent, it could not reach the issue. And it also—
Now, Manzar, we stated that we could not even reach the issue in the interest of justice.
That's correct, Your Honor. This court does not have interest of justice jurisdiction to reach unpreserved issues in an Article 78 proceeding. So for those reasons, counsel's arguments about the use of sealed records are not availing here. Just briefly on substantial evidence, I think both charges were supported by substantial evidence. The 911 calls—
Substantial evidence would have been, again, the video, the statements by the former girlfriend, also the statements by the police officers, as well as the photographs of the injuries to the former girlfriend. What about, now, I believe petitioner had been a member of NYPD for, I think, 12 years or something of that nature, and so the ultimate penalty was termination. Does that shock one's sense of fairness, as this was one single incident in an otherwise unblemished 12-year career?
It does not, Your Honor. This court has held over and over again that dismissal does not shock the conscience as a penalty for domestic violence. I cite at least 6 such cases in my brief at page 41. I'm not aware of any decision by this court where this court determined that dismissal for domestic violence did shock the conscience. And I'd point out that in at least 3 of the cases I cited, Castillo, Marks, and Derudagon, those also involved police officers with long and unblemished histories of employment who were likewise dismissed following a domestic violence incident. It does not shock the conscience. Thank you.
On the substantial evidence, on the substantial evidence case, I just raised one issue, which is my client was never charged with physically injuring his then girlfriend, and he was not charged with criminal behavior. Yet the hearing officer found on both those counts, I submit, that violated his due process, and that issue was preserved in the Fogel letter that was submitted by his former counsel. He did mention it. I believe it's on page 9 of Exhibit 4 of my petition, where he indicates that finding that there was physical injury illustrates bias and procedural due process violation of the trial commissioner, who stated on the record he was not constrained by the pleadings. So he went beyond what my client was even charged with. On the issue of the penalty,
So you refute the photographs?
Excuse me?
You refute the photographs? You don't think that they indicate anything?
No, they didn't.
All the marks around the neck?
There was a dispute about whether that was a hickey or not, and I think I
So,
raised that.
counsel, we have the photographs, obviously, and the, the marks are massive. They're not confined to a small area of the neck. They extend in a manner that would be consonant with hands.
Well, there was no, look, because she didn't this is the problem we have. Because she didn't testify, we don't know what her condition was before. We know that there was some evidence that she was inebriated. We know that there were some other issues. She had some scrapes to her knees. Her initial complaint didn't even concern her neck.
What about the 911 calls that where thuds could be heard? THUDS. And where the former girlfriend was saying, you know, essentially, don't hurt me.
She said, "Don't hurt me," and then
And then the 911 calls indicated thuds as if she was falling or being
Well, when she
thrown
was
about.
asked about that initially, she said, "Oh, he had done something like this, and I have." I mean, it was not even clear if she was testifying about present tense or past tense. But that's beside the point. Without her testimony, you know, we're all relying on, you know, photographs. I think my client was trying to put in photographs of some other girlfriends who had hickeys, and it looked at like a very similar type of marking, and apparently that was.
So, counsel, did you briefly want to address the issue as to the severity of the punishment?
Yes, I do. And specifically, the Marks case to which counsel referred to, in that case, there were allegations of violation of protection, order of protection. There were violations of associating with a criminal. On the Duragon case that was cited, the police officer in that case, I believe, had been placed on probation before. And those cases, you know, we've raised the issue of this matrix that the police department invoked to make sure that these penalties are equitable in some way. And the one thing that the presumptive penalty for something like this is a 30-day suspension with counseling. My client completed the counseling, and that wasn't imposed.
What about the fact that the the sergeant, was unavailable for 2 hours after the incident and did not respond to calls from the precinct captain?
You know, there's testimony on that about what he did. He walked around. Apparently, she had been walking around too. The police didn't even find her at that location. She was at some parking lot away from the building itself. So looked like they both had a fight. They walked out. They each went their own way, but eventually he did respond and he did call. But again, if that's what this is going to hinge on, the fact that this is a person who not only made it to sergeant, but has been so dedicated to helping the youth in his community. He worked for the court system after this incident for 15 months for the police department. He was assigned to Brooklyn courts, and there were no incidents. He was a model, stellar employee.
Thank you so much. Thank you both.
Thank you.
Gelwin v. Di Ratafia, excuse me, Ratafia. Do we have the petitioner as of yet? No? Okay, step up. We don't have a court reporter, but it is, it is 2:40. May the record reflect that it is 2:40. Did you still wish to argue, is that correct?
Yes. Having already prepared, I feel I owe it to my client.
Okay.
May it please the court, Henry Masha, Rivkin Radler, attorney for the respondent, County of Columbia. Columbia County is here on the very limited issue of Mr. Gelwin's.
Could you move the mic closer to your mouth?
Sorry?
Could you move the mic closer?
Oh, sure. Is that better?
Yes.
Yes, thank you.
Very good. Columbia County is here on the very limited issue of a statutory charging lien. The Court of Appeals has said repeatedly that a 3-year statute of limitation applies to liabilities that would not exist but for a statute. And that's exactly what we have here. At common law, a charging lien from an attorney doesn't attach to settlement proceeds. That's what this Court of Appeals held in Coughlin, and as a result of that case, the predecessor to Judiciary Law 475, was passed, which extended charging liens to settlement proceeds. So without Judiciary Law 475, Mr. Galwan doesn't have a claim, which means that he has a 3-year statute of limitations. The statute of limitations here accrued in August 2016, according to Mr. Galwan's own allegations of when the settlement proceeds were allegedly paid, and that was after he had given supposed notice of this charging lien. So his claim is time barred, and the relation back doctrine simply is not available to him. The relation back doctrine doesn't apply to him for 2 reasons. First, the defendants in this case have different defenses available to them. And in this court said in Higgins, and the Court of Appeals recently said in Nemeth, that when the defendants have different defenses available to them, they're not united in interest.
Is there any unity of interest at all?
No, not at all. And in addition, the third prong of the relation back test fails because this was not a mistake. Mr. Galwan stated in his Second Amendment complaint on page 405 of the record that he gave notice to Columbia County of this charging lien before the settlement or around that time. So if he did that, then how could he not have included them in the original complaint, or actually in the original summons in 2016, the complaint that was filed in 2021, and the First Amendment complaint that was filed in 2021? Columbia County was not a defendant. That's not a mistake. That's a strategic decision to get a tactical advantage. Because remember, Columbia County was dismissed from the underlying civil rights claim on the merits with prejudice before the settlement. So Galwan is trying to get Columbia County back in the case to gain a tactical advantage. That's exactly the situation where the relation back doctrine does not apply. And even if you were to disagree with that, Mr. Galwan waived his claim. There are cases that talk about waiting a month or 8 months or a year to assert a charging lien is too much. Mr. Galwan here waited over 5 years to assert this charging lien. So under either circumstance, his claim was properly dismissed. If the court has any other questions, I'll rest on my brief.
Thank you.
Good afternoon. May it please the court, Andrew Gaffel for defendant respondents, the Warshawski Law Firm and Stephen Warshawski. Despite the sensational and grandiose complaint, it is our position that this is a simple fee dispute. Galwan has had a dispute about how much his attorney's fee is worth against his former clients, D. Ratafia and Ackroyd. This arises from a matter that settled in 2016. Mr. Warshawski, or the Warshawski firm, was co-counsel for a period of time towards the end of that case, up until the settlement. And now we have this lawsuit in which the appeal, as it relates to Warshawski, the lower court correctly dismissed 4 causes of action asserted by and between co-counsel: legal malpractice, breach of fiduciary duty, tortious interference with contract, and violation of Judiciary Law 487. For the reasons stated in our brief, we submit that the lower court properly granted that motion to dismiss.
Counsel?
Yep.
So here the plaintiff alleges that the settlement of the underlying action required his consent, and his consent was not obtained to the settlement, yes?
That Mr. Galwan's consent was required?
Say again?
Is your question or your statement that Mr. Galwan's consent was required for his clients?
No, that's his allegation.
Okay.
That's his allegation.
Okay.
So there was a flat fee, from what I understand, that was paid to the Warshawski firm. Was there any, and that was $60,000, was there any gain by way of settlement that inured to the Warshawski firm?
No, I mean that's one of the main points we make in our.
Other than $60K, was that it?
He was separate. When he came in as co-counsel, and there was predecessor.
He is who?
When the Warshawski firm came in as co-counsel, he was retained by a separate contract, a separate retainer agreement that had nothing to. That is not a contingency fee, not a contingency arrangement. Has nothing to do with the contingency fee that's at dispute here, and was paid separately. So he had no interest, he had nothing to gain or lose by the settlement. I mean, there's the allegations that the contract was interfered with because they should have obtained a better settlement, or that Mr. Wachowski persuaded the clients to block him out or not allow him to participate in the settlement negotiations or the pretrial proceedings. There's evidence in the record, clear emails where they instruct him to stop working on the case. I mean, the client's right to choose counsel is paramount. That's it. In terms of the tortious interference with contract claim, it's terminable at will. So you have to allege wrongful means. If Warshawski was financially motivated, and he's not for the reasons you state, because if anything, taking it to trial, he would earn more fees. I mean, there was an hourly component to it too. So he wasn't settling at that time or settling for less or more money. It didn't matter.
Counsel, 1 second. Is Mr. Gelwin outside? Would you ask him to come in, please?
Can't make it up. Can't make it up.
Are you okay? Are you okay?
I was not involved in the accident.
Ah, okay. So you have 5 minutes. You should, if you could use the podium and step up to the microphone, please.
Your Honor, this is an action primarily for charging lien, but also a plenary action for associated torts and breach of contract arising out of my representation of respondents Diratafia and Ackroyd.
Counsel, I apologize. Just to bring you up to speed, we've already heard from the attorney for Columbia County as well as the attorney for the Wachowski firm.
Okay, so I'll skip the introduction then, and not consume my 5 minutes. In this action,
Counsel, why does the tortious interference claim that you're alleging, why does that continue?
That continues, Your Honor, because the law in New York is that when a relationship is formed from a high degree of trust, as it was, if Your Honor is speaking of the tortious interference claim against Attorney Warshawski, that is arising out of the higher degree of trust that is implied in the formation of the relationship itself. If I can
You had a relationship with that firm?
I had a relationship with the firm in the sense that I brought the firm in at the last minute when the clients fired their third lawyer, leaving me again on the cusp of trial to bring.
This created a high level of trust?
No, but if I can pull out my notes, I will refer you to the retainer agreement that Mr. Warshawski entered into without any of my doing or input, in which it states that he is entering his appearance as a subservient lawyer to me to assist in the bringing to trial of the matter that had been going prepared for 5 years by me. And I'll refer you on to the
But counsel, when you join on as co-counsel with another lawyer with regard to a particular client, isn't your primary duty to the client? Isn't the primary duty of both co-counsel to the client, not to each other?
So, counsel, let me just say, if anything that you're referring to is in the record, we can certainly refer to the record because you don't have that much time left. So, if you're referring to anything in the record, just let us know, and we will check.
I'm sorry for interrupting. I'm referring to the retainer agreement that Mr. Warshawski entered into at the last minute, after my 5 years of representation, which he formed with clients, having no involvement with or knowledge by me, in which he inserted a paragraph cited in my brief at his and the client's insistence that he was signing on as a subservient lawyer to me to bring the case to trial according to the theories and the preparation that I had done for the prior 5 years, with a very proper last phrase in that paragraph, subject always to the client's approval, of course.
Do you need to show that whatever actions or allegations you're making were done for wrongful means for the sole purpose of harming you? Do you need to show that? And if so, how specifically, and not in a conclusory way, how have you shown that?
Okay, is Your Honor referring again to the tortious interference claim?
Yes.
Yes, no, I do not believe the law requires that I demonstrate that Mr. Warshawski did the acts that I allege at length in the second amended complaint for the purpose of harming me, so long as that was the effect demonstrated in the substantial pleading. Of course, on this motion to dismiss, from which this appeal arises, the factual allegations which are pleaded at length, far beyond average notice pleading for this purpose in this unusual context.
Was your consent needed in order to sign off on the settlement?
No, it was not. I'm aware that that an issue has been made of whether the fee agreement appears to say that it does not. What it says that we must be consulted, and that we need not, of course, approve it. No lawyer can hold up a settlement for his own purposes or any others if the client wants to settle for good, bad, or other reasons.
Were you asked to step down from the case by your clients?
No, I was not. I was asked specifically to stay on in the April 21st email, which responded to my phone call to the clients advising them it had been called for trial that day. The email said, "We want you to remain on the masthead." In further colloquy that's summarized in the complaint, the explicit request was that I not resign, was that I stay on to assist because they were properly concerned that Mr. Warshawski lacked the background to bring the case to trial himself after he had been on it for approximately 3 weeks when it was called for trial to my almost 5 years, 4.5 years.
Would you please state your position as to Columbia County?
Yes, my position as to Columbia County is that on the principal legal issue posed by the briefs and by Columbia County's motion to dismiss the statute of limitations issue, the statute of limitations hasn't yet begun to run.
The statute of limitation
Hasn't yet begun to run.
Why is that?
Because with respect to secondarily liable parties, the accrual of the cause of action for breach of the
Who would they be?
I beg your pardon?
You said secondary,
Secondarily liable parties.
and who would the secondary liable parties be?
Columbia County, the payor, I now know, I didn't then, I now know the payor of the settlement. As the cases in my brief state, the practice is that the accrual of the cause of action against secondarily liable parties does not commence until after the primarily liable parties, the clients, have refused to pay.
And what case is that based on? Is it in your brief? Yes. Okay, we'll take a look. Thank you.
In addition, that's an offshoot from the larger, more comprehensive doctrine that the cause of action, even against the clients, hasn't begun to run until there's been a hearing fixing the charging lien, and they refuse to pay. That is cited, the Schneider case cited in my, this department cited in my brief
I'll
as well.
give you 2 minutes on rebuttal. Columbia County? You want to respond to anything that was stated?
I would. Frankly, the cause of action has accrued. Mr. Gelwan had everything he needed to start this plenary action in August of 2016, when he says that the proceeds were not paid despite his requests. That's all that's needed. The cases that Mr. Gelwan relies on don't say that the cause of action accrues on a secondarily liable party. Those cases involve summary proceedings to fix the amount of a charging lien, and they don't address the accrual issue. In a plenary action like this one, the court can decide both whether the lien is valid and also the amount of the lien at the same time. That's exactly what this court did in Schneider, on which Mr. Gelwan relies. So the accrual issue, and if Mr. Gelwan's theory is correct, then this case shouldn't even have been started because the cause of action hasn't even accrued yet. So with regard to that, I just don't see any way that the statute of limitations can accrue. It has not yet accrued. It accrued in August of 2016 based on his own allegations.
Thank you. Anything further, counsel?
The only response to what was argued earlier is that Mr. Gelman said that with respect to tortious interference with contract, that he didn't need to show, I believe he said, he didn't need to show that Mr. Warshawski acted with, quote, the purpose of harming me. I mean, that's not the legal standard. Again, because it was a retainer agreement is terminable at will, wrongful means must be shown, and that's the conduct at issue constituted a crime or an independent tort, and allegations of mere self-interest or economic motivations will not suffice.
Thank you. Mr. Gelman, I'll give you a minute.
Yes, with respect to the Columbia County limitations issue, counsel, with all due respect, is incorrect. The cases cited are not summary proceedings, they're plenary actions, as this is, and the plain drift of the plain trend of those cases is that secondarily liable parties, such as the payor, are not subject to suit until the primarily liable party has done something requiring resort to the secondarily liable party by not paying or by trying to escape the jurisdiction to avoid execution on a judgment for the retaining lien. With respect to Mr. Warshawski's counsel's argument that wrongful means are necessary to be pleaded and shown, wrongful means are pleaded and shown at length in the complaint, which accounts for the extraordinary length of the complaint.
Thank you. Thank you. Thank you all.
Thank you so much.
Irizarry v. Zelaya, Lugo et al. Justice Pitberg is recused. The rules of this court are that if there is a tie, a fifth judge will be vouched in.
Good afternoon. May it please the court, Seth Marcus for the plaintiff appellant, Edward Irizarry. Your Honors, the verified complaint in this case, supported by the affidavits of the plaintiff Irizarry, were more than sufficient to state a substantial...
Can you talk louder?
I'm sorry.
Thank you.
The verified complaint in this case, supported by the affidavits of the plaintiff Irizarry, were more than sufficient to state a substantial basis under CPLR 3211G. The Court of Appeals decision in Gotwell v. Siebert, and this court's decision in Reeves v. Associated Newspapers for the defamation claims asserted.
So, counsel, if you're familiar with both of those cases, you know that the counter is to establish a substantial basis in law, right, for the action, for the underlying action. So, given the fact that the flyer, one of the issues in question concerns the flyer that's found on A123 and A124 of the record, has a summons with notice that was distributed to the public as proof of the bad character of Mr. Irizarry. Why is this not a substantial basis for the cause of action sounding in defamation? The summons with notice was never served. It was dismissed.
That's exactly our point, Your Honor, that it is a substantial basis for the defamation actions.
Am I talking to the wrong side?
He represents Mr. Irizarry.
Sorry. I'm preaching to the choir.
Sorry. In dismissing the case, the trial court committed at least 4 errors. First, it ignored damning evidence of the conspiracy to defame Irizarry by disregarding the transcript of the recorded conversation with Defendant Klein and Defendant Klein's other admissions made in conversations with Mr. Irizarry. Second, it ignored binding precedent by giving defendants the benefit of Civil Rights Law Section 74, the fair reporting privilege. That would apply to the summons and notice that the justice had just referred to. Third, it ruled that clearly defamatory factual statements were not actionable opinion. Those factual statements, again, appear clearly, once again, in that summons with notice. And fourth, the court dismissed for failure to plead special damages, even though the complaint states causes of action for defamation per se.
Let's start with the first one first.
Very good.
Okay. What about Supreme Court's concern that the transcript was not the best evidence of the purported conversation between your client and one of the defendants?
Well, a couple points on that, Your Honor. First of all, this is a motion to dismiss. It's not a trial level standard at this point. Mr. Irizarry did provide an authenticating affidavit for the tape or for the recording, in which he testified not only as to the date and time that he made the recording and that it was his recording, but to the accuracy and that the transcription itself was accurate. And also, frankly, best evidence goes to the accuracy of the transcript. And I don't think the client actually properly raised the issue. There is nothing in Mr. Klein's affidavit that disputes the fact that he actually had these conversations or disputes what was put forth in the transcription, notwithstanding the fact that at the very top of that affidavit, he says that he did review the complaint carefully and all the exhibits attached thereto, and the transcription was one of those exhibits. So I don't really think that best evidence would preclude the court from considering it at this level. But again, to continue with the first point, the Klein transcription was important evidence for this case because it specifically implicates Lugo in the plan to pre-file a sham summons and notice. It states specifically that—
What evidence, direct or circumstantial or inferential, do we have that the prior civil lawsuit was a sham or a malicious instrument used to exploit the civil rights law privilege?
Sure. Specifically, if you look at the summons and notice carefully, first of all, it's a summons and notice. It's not a summons and complaint. It was pre-filed in April of 2021, I believe, and nothing was done with it. In fact, the complaint was never actually legally served. Right? And if you compare the complaint to an earlier police report that Ms. Zelaya had made with regard to the supposed incident, that police report was made 2 weeks after the incident, and even then the summons and notice doesn't agree with the allegations in the police report. The summons and notice alleges assault and battery with serious personal injury. There was no report of violence in the earlier police report.
Sorry to jump ahead to, I think, number 3, but assault and battery, are those words that are susceptible to a defamatory connotation? Do they have objectively true or false meanings?
Well, I think they have legally recognized meanings. Both are crimes under the penal law. And certainly when combined with the idea of serious personal injuries, they imply an attack. Right? She was assaulted. She was battered. She suffered personal injuries. Right? And it's clearly the allegation that this attack never occurred. It's a pure fabrication.
Thank you. You have time on rebuttal.
Thank you, Your Honor.
Good afternoon. May it please the court. Ira Goldstein with Morris Duffy, Alonzo, Fairley, and Pickoff for the respondents, Judge Betty Lugo and Lugo for judge. It's respectfully submitted the trial court got this completely right. This case doesn't get past the complaint. It's woefully inadequate. It's first and foremost, there's no specific allegations of or facts of actual malice, which needs to be proven by a substantial basis, which means clear and convincing evidence. And as the Court of Appeals has said, that means convincing clarity. Here we have unconvincing vagueness. It's just all conjecture, speculation, opinion, and baseless inferences.
Well, what about the transcript of the purported conversation?
Oh, the lower court swiftly rejected that for good reason. It's there's no foundation. It's uncertified. Mr. Azari is not a court reporter. He's not a certified transcriber. And again, as he said, it's not the best evidence.
In a motion to dismiss, does admissible evidence have to be provided?
Well, the burden of proof is on the plaintiff, according to the anti-SLAPP law.
But if Mr. Irisari says, I'm transcribing it, I'm one of the two people in the conversation, and this is what it said, based on the tapes, is that good enough?
Absolutely not. There's no indicia of reliability, as the lower court found.
What if Mr. Azari hadn't recorded the conversation but put in an affidavit that said, I had a conversation with X, this is what I said to X, this is what X said to me? That would eliminate a best evidence objection, but would that be sufficient to establish the requisite showing under 3211G?
It would not be sufficient. First and foremost, he relied on that unverified transcript he created, which, if you can't rely on that transcript, nothing derived from that should be relied upon. And in other words, it's fruit from the poisonous tree. But more importantly, the elephant in the room here is the actual recording, which he says he recorded on his phone, a smartphone, a Galaxy smartphone, which is a digital file. Yet he said he sent the tape to the Judicial Commission, which implies that that's the only copy. A digital file, as anyone knows, lasts forever unless deleted and spoliated. So that's why we need that evidence. No one could rebut anything on that recording.
Well, in Reeves, which Justice Gonzalez authored, and which I know we're all familiar with here, she made the analogy to 3211G to summary judgment. And if we're going to stick with that analogy, another principle of summary judgment is that rules of evidence have to be cautiously and guardedly applied, particularly as they apply to the party opposing summary judgment. And I view the plaintiff here as sort of cast in the role of opposing summary judgment. They have to come forward now and show the existence of a tribal issue of fact. If there are questions about the admissibility of the transcript, aren't those better deferred for a trial upon a full development of the facts and circumstances or swirling around the creation of the transcript?
Absolutely not. That he has a clear and convincing evidence standard. The legislature specifically passed this anti-SLAPP law to put the onus on the movement to come forth with actual evidence, not just their imagination, guesswork, and inferences. You need concrete evidence, and there's nothing there. He just guesses. There's no actual evidence of the actual, he says actual malice, but he never actually proves it.
Was there an application for special discovery?
And well, he waived that there's a special mechanism for discovery in opposition to a motion. He waived that. He put his best foot forward, and it's woefully inadequate.
So in addition to the audio tape, can we not also look to Ms. Zeleya's inconsistent statements, her statements to the police in terms of what allegedly occurred when she was petitioning, and then the resulting complaints?
Well, that's actually based on an actual incident where Mr. Irizarry approached her on the street. So this is made out of whole
It's
cloth.
inconsistent, as was stated by your friend, in terms of her statements to the police. I think it was the 7th precinct. The statements to the police at the precinct were inconsistent, wholly inconsistent with the two complaints that were filed.
Right, well, first off, the police report wasn't certified, but even if we look at what's in the police report, it says that there was an altercation. Whether her subsequent civil suit is inconsistent with that police report is not, it has no bearing on whether he pleaded actual malice or correctly alleged it. Because, I mean, we got to protect victims here. There's a reason why that summons with notice is privileged to protect victims, and there's no reason here to take that protection away from Ms. Zelaya. In other words, she's not connected to my client. She was a campaign volunteer, but these were all statements she was made on an election flyer and in 8 tweets, by the way.
I may, with respect to the malice, and the summons with notice was employed, which of course is perfectly permissible under CPLR 305B. The second sentence, though, is curious, where it identifies not only the date that the alleged event occurred, but identified the complainant, the plaintiff in that action, as someone who was gathering petitions, identified Mr. Azari as a candidate for lower civil, and identified Ms. Lugo or Judge Lugo as the candidate that she was petitioning for. Those are sort of odd allegations to put in a summons with notice initiating that action. They weren't necessary to satisfy 305B.
Well, I can't really speak to what Ms. Elia was doing. I mean, again, she's the victim here. We got to tread carefully with the victim. Otherwise, we're going to scare people from coming forward with these type of allegations. And again, there was a basis for this. She was on the street. She claims he grabbed it, which is indirect contact, which again could constitute assault under certain laws. But at the end of the day, it doesn't meet the actual malice standard, and that's his issue.
To what extent does the dissemination of a summons with notice that was never served on Mr. Irisarri constitute or not constitute proof of actual malice?
Well, first of all, that's privilege. That she's allowed to use
What's
that.
a privilege?
The privilege in the CPLR, the Civil Rights Section 74 privilege, where...
But this was not ever a litigation.
Oh, well, it was filed, and...
It was filed and never served.
If that's the case, I don't think that would make a difference as to my client. And another important fact, she filed her actual complaint well after this election was over, which undermines their argument.
The summons and complaint was privileged?
Under the civil rights law, that's a privileged act. She's allowed to put that on the flyer. They specifically require that Civil Rights Section 74.
Unless the Williams exception applies.
Right, yeah.
Which
So
doesn't apply
that's-
here because Williams requires non-conclusory allegations, which that's all he comes up with. There's no actual factual basis
But
for
the
anything.
fact that it was never filed is not of any consequence? That it's on the flyer, but in fact, the summons and complaint was never actually filed?
They were filed.
I mean, was dismissed?
Well, they were dismissed on procedural grounds for
Dismissed
lack
for
of service.
failure to serve.
Well,
Those are not minor.
It was defective
procedural-
service.
Those are not minor procedural grounds viewed within the context of what's before us right now.
Well, they were served. They was found to be defective service.
Thank you.
Thank you.
Good afternoon. May it please the court, Mark Fraden for Respondent Raymond Klein.
So Mr. Klein was the consultant, is that correct?
Mr. Klein was
Political
contracted to handle.
consultant to Judge Lugo.
Mr. Klein was contracted to handle petitioning. He was not a consultant during the campaign.
Okay, I have him as a political consultant who was hired by Judge Lugo. That is incorrect?
That's incorrect. Mr. Klein only worked on the petitioning.
Wasn't he working on the petition as a consultant?
If you want to call it a consultant, call it a consultant. But the point is that he wasn't working on the campaign at the time when it is alleged that the flyers were published. And if you want to believe the transcript, which the content of which is denied.
The content which is not what?
I'm sorry?
You said which the content is not what? Finish that sentence.
I said the content is denied.
Is denied.
Yes, Mr. Klein submitted an affidavit that he did not create the subject flyer. He did not tweet the subject tweets. He doesn't know who did.
Did he deny having that conversation with Mr. Azari that formed the basis of the transcript, so to speak?
He did have a conversation with Mr. Azari, but the accuracy of that conversation is questioned.
So
Is denied.
did he deny the substance of the conversation? Did he deny?
Yes. Yes.
So do we have issues of fact then that militate against dismissing the action?
No, because the plaintiff here was required to meet his burden of proving a substantial basis. The transcript is not admissible for many different reasons. I'm happy to go through them. And I'd like to also point out that the affidavits that are in the record here were not submitted to the lower court. The affidavits, I'm being forced to respond to them for the first time here. They were submitted in opposition to other motions, and I believe this is, something that's very unfair that it's been included
Which
in the record.
affidavits are you referring to?
All of them. And you can even look at the affidavits themselves. They say, you'll see that line number 2 of each of the affidavits says submit in opposition to defendant Zalea's motion. Line number 2 of one of the other affidavits submit in opposition.
If these affidavits were not part of the record before the court when it made this decision, why didn't you move to strike them from the record?
I did, and they're in the record. But
So your application was denied?
yes, and if the court will allow me, I'd like to make an application now for leave to re-argue. I believe
That
it
wouldn't be
was,
before us.
I'm sorry?
That would not be before us.
Okay, but I believe that the court misapprehended something. I don't know why they were included, but they were not. These affidavits were from other motion sequences. But all of that being said, the affidavits are not sufficient to to prove a substantial basis because they are not based on personal knowledge. If you look at number 50 in the affidavit dated 9/11/23, it states that
Whose
the
affidavit?
the affidavit of the the affidavit of the plaintiff, of the appellant, it states that the affidavit is based on inferences from the complaint, inferences drawn from the complaint. And that's not sufficient to form a substantial basis, which is supposed to be able to support an ultimate conclusion of law or fact.
If we were to find that it's at least arguable whether the transcript is admissible, would that fatally undermine your position on appeal?
Whether or not it's,
Let's assume that we find, well, you know what, there's a tribal issue of fact, or there's an issue of fact, or we have to await development of the record as to whether this transcript is admissible, and so we're going to consider the content of it on this appeal. Would that be fatal to your position?
you know, it's my position that the transcript shouldn't be considered. And my client submitted an affidavit that he had nothing to do with with the flyer and the subject tweets.
Well, that would put a lot of litigants in a curious position that they're left at the mercy of their adversary to agree that something happened.
I'm sorry?
It would be interesting if we left it the matter of the admissibility or the establishment of a fact to whether the parties agree to that fact. Mr. Azari says one thing, Mr. Klein says another. We're supposed to, we usually our default in that situation is to find there's an issue of fact. Are you saying that because the parties don't agree here or the actors don't agree, we have to default to casting aside the evidence?
Well, the burden is on the plaintiff to prove that there's a substantial basis.
So the only way a plaintiff in an action governed by SLAPP can prevail is if all of the parties agree on the material facts.
I'm not saying that's the only circumstance, but what I'm saying is here, this transcript is not reliable for so many reasons, and it's inadmissible for so many different reasons, the court should not consider it. It violates the best evidence rule. The fact that it's a surreptitious recording that was made by an attorney or at the direction of an attorney for the purpose of framing a complaint makes it inadmissible. And there's case law that I cite in my brief. That's the Meacham case and the Cornaroli versus Borghi, Judge Gammerman decision. There's the fact that the plaintiff himself claims to have transcribed this conversation. He's not certified in transcription. And it's a conversation that supposedly it's not claimed to be under oath, the conversation, which also makes it unreliable. And the statements were denied. The respondent Raymond Klein submitted an affidavit stating that he doesn't know who created the flyer and who published the flyer.
Thank you.
Thank you.
Counsel, was there an application in opposition to the admission of these affidavits?
There was prior motion practice before this court with regard to the use of the affidavits, specifically with regard to the Klein appeal. And there was one affidavit that was related to an appeal that was settled, that was stricken, but the remaining two affidavits continue to be in the record, and there is an order in this court's file to that effect. I'd like to just briefly address a question by the justice with regard to whether or not permissive discovery was taken under what I assume was CPLR 3211G3 is what you're referring to. It was not. And the reason it was not is because the plaintiff believed, I think with good reason, that he had more than enough evidence to satisfy a substantial basis standard, which is what applies here, and therefore such discovery wouldn't be necessary. And I'd also like to briefly address what I believe counsel is sort of conflating the clear and convincing evidence standard under 76A with the substantial basis standard under 3211G. Because this is a motion to dismiss under 3211G, it is substantial basis that applies. Clear and convincing may be the ultimate standard that applies at trial, but right now, for purposes of looking at the complaint and understanding whether or not it can go forward, the substantial basis.
If we were to agree with your friends and the judge below that the transcript is inadmissible at this juncture, would you still be able to survive the 3211G standard?
I think, I think so, Your Honor. First of all, we don't need to necessarily rely purely on the transcript for client statements, as you pointed out. Mr. Irizarry had these conversations. He's qualified to put in his own affidavit that I had these conversations with Mr. Klein, and this is what was said in those conversations, and that creates a material issue of fact implicating Mr. Klein and Ms. Lugo in the larger defamation.
Thank you.
Thank you.
Kim v. XP Securities. Yes, you may proceed.
Good afternoon, Your Honors. May it please the Court, Joshua Fulop of Kazowitz LLP for the appellant XP Investments, XP Securities. Respondents' repeated and admitted violations of XP's policies gave XP cause to terminate him under the plain language of the parties' agreement.
Are you referring specifically to his alleged use of crude language and so on?
It's the use of his crude language. It's also his insubordination.
Okay. With regard to the crude language, isn't there substantial evidence in the record that this was part of the culture at your client's firm?
So that's what the respondent submits. I submit there.
Well, I'm looking at the depositions of the people who worked at your client's firm. It seems to me there's substantial evidence. They all agreed that this is how everybody behaved, and that there was no action taken against him until XP became concerned that his product was not going to be financially viable. I thought that was a surprising turn of events, that they tolerated it for fine for 2 years, and then when the financial issues changed, they became concerned about his behavior.
So we submit that they did not tolerate it for 2 years, but more importantly, the depositions that are referenced are depositions of his team members. So it's no surprise that with someone as crude and obnoxious as the respondent was acting, that his team members would have experienced the same hostile environment that he in fact created.
But counsel, how can we decide this as a matter of law? Wouldn't that require some more factual basis that maybe a jury should consider some issues of credibility?
I appreciate that question, and we believe it's a matter of law because the respondent does not even contest that he willfully violated XP's policies. And on that basis alone, based on the contractual language, XP should be successful. What respondent has stated is that there's a seriousness requirement component to the inquiry. And we submitted in our brief why, under the rules of contract interpretation, that's not required. All that's required, and it's commonplace in numerous employment agreements, if you violate the rules and policies of the company, you're subject to termination.
But your clients claimed that they had given him a final warning, and I couldn't find any actual documentation of that in the record. I looked, and is there any actual written documentation of the alleged financial warning given to Mr. Kim?
So the warning was an oral warning.
And there was no, so you're claiming that that was the final step in a process of deciding that he had seriously violated a rule, and that there's no written documentation of it, no notation of the conversation having occurred, no documentation of the conversation that was made with him?
I appreciate it. That was not the precipitating factor for his termination, but I understand it was only an oral warning, and it followed what was previously an investigation that had resulted in a finding by HR that he had committed misconduct. So I appreciate there's an issue of fact there, but I don't believe that creates an issue of fact in the case as to whether or not the conduct was willful misconduct.
Well, fundamentally, we have to determine whether the definition of cause is unambiguous, right?
Correct.
Because your friend points out in his brief, by his lights, that the formulation in paragraph 11B is reasonably susceptible to more than one meaning, and that the phrase serious misconduct is a noun phrase, and so willful would modify that noun phrase.
Exactly, and that is the crux of the issue, is how to interpret that phrase, which is
So how do we interpret that phrase? It says willful or gross serious misconduct.
Sure, and the interpretation is that the conduct need only be willful misconduct or gross serious misconduct. And the reason for that is that if the conduct were intended to be willful serious misconduct, there would be a comma after gross. So in other words, it would say willful or gross, comma, serious misconduct.
Counsel, doesn't that suggest that there's some ambiguity in that standard? I mean, it seems to me that there are, as you point out, many ways of reading it, depending on where you think there should be commas. Commas are often disagreed about. Doesn't that create an ambiguity in the standard?
We don't believe so. We believe that the comma is the reason that there's no ambiguity. And if you look to the
There is no
doctrines,
comma. You mean the absence of a comma?
the absence of a comma. Thank you, Your Honor. I'm sorry. So the absence of a comma, and if you look to the doctrine of the last antecedent, which we cite, that is New York law. We've cited another case that specifically rejected respondents' view on the interpretation. They've submitted nothing besides this one case, right, which is outside the circuit, and it was not interpreting a phrase with a disjunctive. It's fundamentally the job of the court to interpret that language, and given the interpretation that it's willful misconduct, respondent doesn't contest that he committed willful misconduct. On those grounds, we're entitled to summary judgment. I know I haven't addressed the second motion we have. I can do that on rebuttal.
Yes,
to
please.
the court. Thank you.
Good afternoon, Your Honors. Lawrence O. on behalf of plaintiff respondent. May it please the court.
So do you concede that that section is willful or gross serious misconduct?
Well, it's plaintiff respondent's position that willful or gross serious misconduct is indeed a noun phrase, as was mentioned by one of the justices. And the primary reason for this is the context of the phrase. We can all agree that gross serious misconduct is something that would be actionable and terminable for cause, gross serious misconduct. The question now is whether the willful misconduct must be willful misconduct or willful serious misconduct.
And why shouldn't we apply the last antecedent rule of construction?
Well, we shouldn't apply that rule because of two reasons. Number one, it would create an imbalance here. There is an absence of a comma precisely because there is a purposeful usage of the noun phrase. The parties agreed to not have a comma for the purpose of emphasizing the noun phrase of serious
I would
misconduct.
have liked to have been privy to those negotiations over that comma.
Yeah, I mean, when did this take place that they stated, I want a comma? No, I don't think there should be a comma. Yeah, there should be a comma. There should be a semicolon. I mean, when did this conversation take place that they agreed as to the absence or presence of a comma?
Well, I think that it's instructive to look immediately above in paragraph 3 of that same paragraph, because there is an equivalent usage of a noun phrase, and I direct the court to deliberate or grossly negligent unauthorized disclosure. That is an exactly duplicate phraseology
Where does that
here.
appear in the record, counsel?
Well, it's part of the employment agreement, Your Honor.
Okay.
Yeah. So it's,
Right, which paragraph?
it's paragraph 3.
Great.
Three.
So it's
The
little
deliberate
3.
or grossly unauthorized disclosure by employee of any confidential information. I'm looking at this, and I only see one comma. Excuse me, I see two commas, but not where there's a description. Willful or gross serious misconduct by employee in the performance of employee's duties and responsibilities to the company, comma, including conduct. So, I mean, there seems to be a shortage of commas
Well, I would proffer to
in
the
this
court
section.
that it's not a shortage if it's an intentional omission of that comma to isolate and focus and create the construction of the noun phrase. And when
So-
you look at little 3 above, deliberate or grossly negligent unauthorized disclosure, there is also the absence of a comma right before unauthorized disclosure. And that's intentional. So the parties here are clearly using the noun phrase.
Well, that's just it, counsel. How do we know that any of this is intentional? That's the issue. So this goes to, I think, to some extent, whether this is ambiguous or it is not, or it's unambiguous. But I thought that your friend was stating that that your client concedes that his conduct was willful.
Well, I don't think that there's any disagreement that there's some conduct here that was in fact willful. Supreme Court mentions it, that there's no disagreement that the conduct here is willful. The question is whether it was serious misconduct.
And that's where I want to go. The language that is cited throughout the record is shocking. I couldn't say even one of the words here or one of the phrases here without offending everyone. The ethnic slurs, shocking. So to what extent is that not willful, serious misconduct, Counselor?
Well, Your Honor, these are deeply disturbing and offensive statements to professionals like us. But as the Justice mentioned—
To like regular old people is fine?
No, Your Honor. What I mean to suggest is that there is a deep record here of 20 witnesses who were deposed, well over 3,000 pages of transcript record, not just members of Mr. Kim's desk who were deposed, who were called by a plaintiff, but people who were on his desk who were also called by the defense. One of those witnesses, Gus McKay, had difficulty even refraining from cursing using the F word during his own deposition.
Are we not talking about the F word?
Let me go on
Counsel?
to—
You know that that's not what we're talking about.
I understand exactly what the court is referring to, and I'll address that head on. The ethnic references that the court is referring to were first of all turned over in WhatsApp messages during litigation. These weren't even in existence and known by the defense until after termination. Moreover, what's arbitrary or irrational about the defense's conduct here in exercising its discretion to terminate Mr. Kim is that they purportedly disciplined him for exactly the same conduct for the use of a disability. And I think the court is aware of what I'm talking about. And after disciplining him for having sent an errant email to not just another colleague, but to a client, he was relieved of any discipline by the company withdrawing that warning letter in exchange for money. The company came to him.
What do you mean in exchange for money? I
In
think
exchange—
you need to be a little more.
The record is clear that XP's CEO came to Mr. Kim and proposed that they would withdraw the letter giving him the warning letter
In exchange for a penalty?
in exchange for a pay reduction. Because all of the division desks were doing so poorly, he needed to cut costs, and he proposed this at XP's own behest. This letter, this warning letter, was retracted. So
And
this
that
is
had to
what
do
I'm
with
saying.
his untoward communication to the Barclays client, correct?
That's correct. Yes, that's exactly the
Counsel,
incident.
to get back, the handbook, we're talking about this handbook, right, which talks about non-discrimination and anti-harassment policy and complaint procedure. And the handbook talks about all individuals are treated with respect and dignity. And employees who fail to maintain proper standards toward their co-workers, et cetera, are subject to appropriate disciplinary action up to and including discharge. Given that, and given the purpose of this policy and what the handbook says, is it even an issue as to the quote-unquote culture that these individuals were working under or in?
Well, there.
Because you can say, oh, well, everyone used the F word, or everyone used this word, or everyone used that word. But this seems to be pretty clear that no one should be using these words whatsoever, and that all individuals are to be treated with respect and dignity, which would go beyond even those words and words, relating to a quote-unquote disability. I guess I'll phrase it that way. So why are we even looking at culture? Why is that even a consideration?
Well, culture is only half of it, Your Honor. The other half of it is that all of this behavior and conduct by Mr. Kim was known to XP at the time, and XP did nothing about it. In fact, what XP did was they constructed a sham investigation in
Aren't there
October.
complaints?
Well, again,
Didn't at least, how many people, 12 people complain? I mean, wasn't the invective directed at not only employees who were subordinate to Mr. Kim, but also executive staff?
these are individuals that the defense will claim are complaints that were generated towards Mr. Kim. But if one examines each of those instances, it becomes clear that not every single one of those are specific complaints. Number two,
They do complain about hostile work environment, don't they, as well?
well, that's why I think it's important to look at a case like Parneros versus Barnes & Nobles, because that case has the exact same parallel facts as the facts that we're dealing with here. In that case, in fact, I'd say that the facts were even more egregious because there was an allegation of sexual harassment.
You know what? That's apples and oranges. This is pretty bad.
Well, it may be pretty bad, but the whole point of this is that what we're dealing with here is a standard of not of maintaining their promise to uphold the duty of good faith and fair dealing. And that means that XP is required not to behave or act in an arbitrary or irrational manner in exercising its discretion to terminate Mr. Kim. You can go on and let this type of behavior continue and do nothing about it until such time as Mr. Kim submits a letter to management asking whether management is going to uphold their obligations to build out an electronic trading platform, and it is only at that time that he is then suspended and fired. There is an October investigation that they conduct, purportedly under the auspices of trying to get at a dispute between him and another individual. And the subject matter of this investigation was never disclosed to Mr. Kim.
Wasn't that, oh, I'm sorry.
Go ahead.
Are you talking about the London report?
The London reports.
Wasn't that initiated by a complaint by Mr. Kim against?
That's correct. And if you look at the
Against
subject
Mr.
matter,
Wood, right.
if you look at the paperwork on the London reports, you'll find something striking, which is that they were altered by the head of HR.
Thank you, counsel.
Thank you. I just want to be conscious in managing my time and get to the second motion we have. And if I have time, I'll go back to the summary judgment issue. On the motion in limine, respondent's claim for lost profits rests entirely on the testimony of his good friend, Seth Johnson, that because Mr. Johnson had run one business successfully, he can predict the future success of another. His expert, Seth Johnson, seeks to testify based on his experience alone that respondent's failing business, which had not generated a single dollar in commissions or profits.
Counsel, regardless of the merits of that, isn't the trial court's denial of your motion to preclude not reviewable at this time, but only in the context of an appeal from the judgment rendered after trial based on our decision, on one of our decisions from 2007?
Your Honor, I'd point to the Shire v. Shire and Melcher v. Greenberg-Trarg decisions from this court that we cite in our papers. The standard is if the motion seeks to determine the proper measure of damages, it does affect the substantial rights of the parties. It impacts the substantive rights of the parties in the case, and it is immediately appealable. And that's Shire v. Shire and Melcher v. Greenberg-Trarg.
Isn't that an evidentiary ruling in terms of the preclusion of the expert?
I'm sorry?
Wasn't the preclusion of the testimony of the expert, was that not, or is that not an evidentiary ruling?
It absolutely is an evidentiary ruling, but it's more than that because it gets to the entire question of whether or not the respondent can pursue lost profits in this circumstance.
But we've said as recently as earlier in 2025 in Mokta Dairy versus Apis Capital Advisors, that rule still lies, that the ruling, that there's no appeal from an evidentiary ruling to preclude a testimony of plaintiff's expert.
Understood. I just direct the court again to Shire v. Shire. It's a 2022 case from this court, and Melcher v. Greenberg-Charg, a 2018 case. And it does, while that is the general rule, there are exceptions. And one exception, such as the one we have here, is where the issue would actually determine the amount of damages that are recoverable in the case. And
Here, it doesn't determine the amount of damages, it leaves the door open to plaintiff proving damages.
There would be no means for plaintiff to possibly recover lost profit damages without his expert. And equally, lost profits are not available in this case, which was part of the determination that we saw. If I just have one more second, the only other thing I'd like to wrap up and say is that the respondent was a managing director of XP. He was one of the highest people in the company. He managed a team of 10 people approximately, right, in New York and in London. And his conduct, and it's set forth in text, it's set forth in numerous complaints, right? His conduct was reprehensible. And respondents' view is we can't do anything about that until it rises to some level of seriousness that is undefined. What I would point, Your Honors, to is the employee handbook, which specifically says you can be terminated for engaging in the following conduct. XP holds its managing directors to a higher standard.
Definitely, but I think the argument was that you waited, I mean, this conduct was ongoing, and you waited until, the XP was no longer profitable, or you did not believe it was as profitable as you thought it was going to be before you terminated.
Respondent's business, respectfully, was never profitable, and there was no
You
chance.
continue to pour money into the project. But we have your briefs. Thank you so much.
Thank you.
902 Associates v. Union Square 902. Yes, you may proceed.
May it please the court, Maxwell Breed of Prior Cashman LLP for the appellant Welly Chow. The order on appeal granted summary judgment on liability on a guarantee of an office lease. Now, there are two problems with this. The first problem is that the respondent here, the landlord, did not refute the showing made below that the guarantee had been discharged. And the second problem is that the guarantee was discharged as a matter of law.
How was that?
The guarantee was discharged as a matter of law, Your Honor, because there were two subsequent writings that materially altered the risk for the surety or the guarantor.
So you're talking about the modifications?
I'm talking about the modifications, Your Honor.
So those modifications, they dealt with the when the rent would become due based upon the landlord's turning over the premises to the tenant, right? They only dealt with when the rent was due. They did not in any way, the rent commencement date.
That is correct, Your Honor, that they did do that, but they did more. With respect to the first letter modification in 2011, August 2011, that letter modification also imposed an additional monetary obligation on the tenant that was not there under the lease that was originally drafted, which was to provide for payment of electrical charges before the commencement date as defined in the lease. Secondarily, that agreement also relieved the landlord of an important obligation, which was to deliver the premises in the condition required by the landlord's work provision.
But it also states all other terms, covenants, and conditions of the lease are and shall remain in full force and effect and are hereby ratified and confirmed in all respects.
That's the lease, Your Honor. The guarantee is a separate instrument. And what's important here...
But the guarantee was subject to all lease modifications, right?
Yes, and Your Honor, that's absolutely right. And I'm glad that you brought that up because the case law around guarantees and the modification of surety obligations is such that when even in the presence of language like that, providing that the guarantee shall extend, when the underlying agreement, the lease in this case, imposes additional risk, imposes additional monetary obligations, the surety, the guarantee, the guarantor still has to sign off. And this is case law that was not addressed either below, it was not addressed by our adversary here on appeal, and it is critically important because if changes of form, like Your Honor mentions, and a mere amendment or a mere extension, a mere renewal, impose something greater, a higher rental obligation, some other form of
I'm not
monetary
following
risk.
you, counsel. So in paragraph 4 of the good guy guarantee, it states that the guarantee shall remain in full force and effect as to any assignment, transfer, renewal, modification, or extension of the lease. Aren't you talking about modifications?
Yes, Your Honor.
So what's the problem, particularly since the guarantor signed off on the 2013 stipulation on the tenant's behalf?
Now, Your Honor, the guarantor signed off on both of these agreements, actually.
I beg your pardon?
The guarantor signed off on both of these agreements, actually. And that, though, is not important because the obligation that a guarantee be ratified to continue in full force and effect, with respect to a modified lease or an increased surety obligation, as is the case here, cannot be read into the instrument or the agreement that imposed that additional requirement. And the absence of the ratification language with respect to the guarantee is controlling here. And what's important here, and we introduced on summary judgment below, evidence showing that the same guarantor and the same parent landlord company had modified other leases, in fact, reducing lease obligations. And the landlord, the same parent company, same landlord signatory, required that Mr. Chow separately ratify those agreements with respect to the lesser obligations.
But the fact that a landlord took that position as to one set of leases doesn't mean he has to take it as to all, does he?
No, Your Honor, but
I'm
I
not
think
aware of any principle like that.
there is no such principle, Your Honor, but however, it shows it's evidence of intent, and intent matters because the guarantee,
Intent of what?
the intent here, the absence of the guarantee ratification language is dispositive. We show that there was guarantee ratification language in similar circumstances with the same parties. The fact that it does not exist here is what we argue is dispositive, Your Honor.
Okay, thank you.
May it please the court, Magda Cruz for 902 Associates, the owner.
So, counsel, in the 2011 letter and the 2013 stipulation, were there additional obligations placed on the tenant so as to maybe have this now deemed a new lease as opposed to a modification of the existing lease?
There were no material additional obligations, and I'll be specific regarding the 2011 letter. That was solicited by the tenant. He wanted to have early access to the premises, and the only obligation, quote, obligation, that that letter talks about, this is at page 276 of the record, is that he now has to pay for electrical charges for the time that he is in possession. And my adversary, and also to provide a certificate of insurance.
In fact, that letter, he didn't have to pay the fixed rent during that.
That's right. He did not have to pay any fixed rent during this time. And my adversary contends that he gave up some major right because now the owner allegedly does not have to comply with his obligations to provide a proper premises according to the work obligations. That's absolutely untrue. This letter even specifically says, I think Justice Weber pointed out, states that all other conditions of the lease remain in effect. And with respect to the 2013 stipulation of settlement, that stipulation of settlement, Your Honor, did not make any changes to the lease. In fact, it comported with the lease. It added the lease commencement date, the rent commencement date, and the expiration date, which the lease itself at paragraph 78, I believe, specifies that the parties had to do. So one of the material terms of the stipulation actually comported with the lease. As to other aspects of it, it had to do with resolving disputes that the parties had regarding the work that was being done to get the premises up to the standard that the tenant wanted. It has nothing to do with an extension of the term, adding more space to the premises, changing the lease terms, none of those things that would have applied to the concept of a novation of a guarantee. We have here, Your Honor, an unconditional guarantee. It specifically says that it is binding on the guarantor even if there are modifications to the lease. The case law is very clear. In fact, in one case in particular that the Supreme Court cited, it is a decision by this court in which 3 of your honors were on that panel, stated, this is the Deco, I have it here, Deco Towers Associates versus Fish. There was a settlement there too, and the guarantor said, oh no, you know, this settlement changed the terms because there was some kind of a waiver of rent, and your honors said absolutely not. When you have an unconditional guarantee, as just like the kind that we have here, you have to have a situation where the parties recognize that the old lease has been extinguished and a new agreement or a new material provision has been superimposed on the lease. There are no such facts in this case, Your Honors. This case was properly decided by the lower court, and we ask that it be affirmed.
What's the relationship between the tenant and the guarantor?
I think that he is a principal of the tenant, Your Honor.
I'm asking because the tenor of the arguments presented kind of indicate that the guarantor was snookered by the 2011 by the stipulation, excuse me.
By the stipulation?
Which he signed.
He signed it, yes, so he was aware, and he never asked for an extension or a ratification of the guarantee. But he is a principal of the tenant.
Thank you.
Thank you.
To correct one important misstatement, Mr. Chow was a principal of the tenant entity. Mr. Chow has not been affiliated with the tenant entity since before the arrears arose under the lease that's at issue
I thought
here.
Mr. Chow would lease properties and then have folks come in and use those properties. So he would lease properties all over the city or whatever.
Well, not Mr. Chow, his
The-
company,
the
Micro Office
company.
Solutions, and they had individual entities for each
Right,
of the leases. So yes, that was the business. It was the Micro Office business, and something of a predecessor or
We were.
something like WeWork, exactly. And so Mr. Chow was not in control of the tenant entity at the time that these arrears arose. That is very important, and that was developed on the record
So
below.
again, as my colleague had asked your friend, what were the material changes which would lead to a new determination as a new contract?
Well, it needn't be a novation, and I understand that we argued that each of these agreements constitutes a novation. What it really is, the standard here is, did the risk profile change for the guarantor? And we argue that in the case of both of these agreements, it did. In the case
Have we
of,
ever said that in any of our cases, that that's the issue?
yes, Your Honor, I believe that Loho v. Batista is clear on that.
Did we say that in DECA?
DECO is a different case, Your Honor, because
I know, I sat on it as did Justice Pittsburgh and Justice Gesmer.
but it's a very different case, and I'm glad that we're discussing that as well, because in DECO, it was not there was no additional monetary obligation imposed on the guarantor. The guarantor was arguing that because in the context of this breached stipulation of settlement, that the arrears under the lease would have been waived had the tenant vacated timely. The tenant didn't vacate timely, and so the guarantor, I'm sorry, argued for novation, and this court said there is no novation because the lease really wasn't touched. This was a settlement
How
agreement.
was the lease touched here?
Well, the lease was touched here with respect to both of these agreements, which again were more than a decade ago, not after the arrears arose. This was at the inception of the lease in the case of one, and 2 years later in the case of the other. The first, with respect to the 2011 agreement, resulted
But your
in.
friend stated that your client requested.
Well, that's clearly not put forward. That's not a part of this agreement, which has to be interpreted by its four corners. The agreement does provide that it does provide
So
two
the
material.
payment of the electrical, for the electrical services, is that what you're saying is the increased risk? Because
That's-
you weren't paying rent during the time that you had the possession
But that's-
pursuant to the letter.
That's one increased risk, Your Honor, and I think that the bigger one actually is the deletion of Article 89, which allowed it vested the tenant with a lease cancellation option in the event that the landlord did not deliver the premises as required by a date certain. And the landlord
That's
was.
to the benefit of your client?
That would have been to the benefit of my client because had the landlord complied with its obligation, which
But your client was in the premises, right? That's why they had to pay
Well,
the
the-
electrical.
well, the tenant was
what-
in the
what would-
premises,
What would
correct,
be the
yes.
point of having that provision?
well, that is still an additional monetary obligation on the part of the tenant entity that was not
But your
embodied.
client wanted to be in the premises. That was the whole point. Because I thought that there was an issue with the turnover of the property, and even at some point, the landlord stated that the premises were not in a condition to be turned over to your client, but your client the tenant wanted the possession of the premises.
Well, the tenant agreed to possession of the premises,
Yes.
and the landlord relieved itself of certain obligations. It also imposed additional obligations on the tenant in the form of the additional rent for the electrical
Thank you.
service.
Thank you, Beth. Sanibel Trading?
Good afternoon, Your Honors. May it please the Court, Marisa Antonelli of Vincent and Elkins for the appellants. Your Honors, the trial court made two errors that impact the right of foreign instrumentalities like PDVSA to be served in accordance with the Foreign Sovereign Immunities Act when they are sued in New York courts. First, the trial court held that service on PDVSA's former service agent, Corporation Service Company, complied with the FSIA, even though...
But do we even need to get to that? Because under the note agreement, weren't there requirements or statements as to how they were going to be served? How you were going to be served?
Your Honor, that is the trial court's second error. The trial court misinterpreted a sovereign immunity waiver in the note agreement at issue to also waive FSIA service requirements. But if you look at that section, which is section 9.15C of the note agreement, it does
So in
not...
section 3.01X, does it state that that you waived the right to be served pursuant to the FSIA?
The section that the trial court looked at was section 9.15C of the...
The 9.15C waived any immunity from any legal process and agreed not to assert any claim that it is immune from any legal process, whether through service of notice or otherwise.
Exactly, Your Honor. And so what that provision does is it waives PDVSA's right to say, you cannot serve me because I am a foreign instrumentality. What it does not do, having waived sovereign immunity, PDVSA now has the right to be served in accordance with specific FSIA requirements. And consistent with that, the very next section Section 9.15D,
which appointed Corporation Service, CSC, as your, as the agent for service or process.
that's correct, Your Honor.
And at some point, CSC stopped being your agent for service?
Yes, so
And that was because, before I
They
get to
weren't
that,
paid.
I was trying to avoid saying that part. I wanted to say, but no, you never notified anyone. Did anyone know that that was no longer your service agent?
so my client is the ad hoc board of PDVSA.
Did anyone know that CSC was no longer the agent for service?
No. What we know is that as of 2019, under United States sanctions against PDVSA, any U.S. company, including CSC, was prohibited from transacting any business with PDVSA.
But didn't D give you irrevocably, not you, your client irrevocably appointed CSC. And in order to move beyond that irrevocable appointment, Provision D gave you a couple of options. But if you didn't avail yourself of either of those options, isn't CSCA, at least constructively and for the purposes of the CSC, for the purposes of the note agreements, you're bound by whatever they do or don't do in their role?
Well, our client is actually unable to appoint a new service agent because of sanctions against PDVSA. So our client is authorized to accept PDVSA's interest in the United States. Our client is the ad hoc managing board of PDVSA that was appointed by the
So
Democratic.
you're saying that there was no way to comply with the part that says the issuer agrees promptly to designate a new agent in the county of New York?
Correct, because
And so, because of that, your adversary's client should bear that burden because of the sanctions, or it should just be a wash for everybody?
so the consequence for my adversary, Your Honor, would be to serve our client through another method authorized by the Foreign Sovereign Immunities Act.
But why
And-
should your adversary bear that burden instead of you?
Because the special arrangement for service of process that was set out in the note agreement is no longer possible to perform without
That doesn't
violating.
answer my colleague's question. So it can no longer be performed, not because of any thing that your friend did, or the adversary did, but because of your relationship with CSC, whatever it is. So why should they bear the burden and not you?
Because in this unique context with the Foreign Sovereign Immunities Act, these are special privileges afforded to sovereigns. And I'll point the court to the S.A. Merval case, which is cited on page 24 of our brief. In that case, an instrumentality designated an employee to accept service of process.
I'm looking at all the efforts that were made to effect service. The attempts took place over a period of many months, yes? With extensions provided by the court. Service was effected on Paul Hastings, who represented the defendants, Hogan Lovells, who provided an opinion letter to plaintiffs, to Horacio Medina Herrera, the head of the issuers ad hoc board in Florida. And none of that worked. So what recourse was there available? I mean, I guess I'm rephrasing what my colleagues are all asking, which is, you said CSC, that's it. And you didn't, your people, not you, your client did not appoint anyone else. And the court finally said, well, you served CSC, this is done. You've done everything that you could, this is done. What's the problem? I still don't get it. I'm looking at this, the FSIA lists several methods of service. For example, methods that are in accord with any special arrangement between a plaintiff and a foreign state or an entity owned by a foreign state. So why wasn't there compliance when why wasn't there compliance with FSIA?
Yes, so in terms of the recourse for the plaintiff, the special arrangement, our position, that's not available because it would be basically illegal to carry out that special arrangement because of United States sanctions that prohibited CSC or any other company from doing business with PDVSA. But 1608B3 of the FSIA is essentially an alternate service provision. A plaintiff can ask the court to order service in a way that will afford actual notice to the defendant. And that is what we said below, and we've said in our brief that the plaintiff should have done here. And we would agree that if this case is reversed and remanded, that given the particular situation in this case, an order from the court under 1608B3, even ordering service on my firm as counsel at this point would be sufficient.
To the extent that the president of Venezuela, recognized by the United States, created an ad hoc board for the issuer, and to the extent that Mr. Medina Herrera was the head of that board, you would still say that service upon him did not provide notice?
No, Your Honor, and we're just asking that the technical requirements of the FSIA be complied with because it has implications for PDVSA across many other cases. So the way that plaintiffs proceeded was simply to serve Mr. Medina. Mr. Medina is not authorized to accept service under Venezuelan law because there has to be a parallel authorization under Venezuelan law with the
So
attorney.
you're saying that for all actions now, it would require, all actions now have to be under the FSA, right?
Yes, so plaintiffs have the opportunity because the first two prongs of the FSIA 1608B are not available. They can go to the court under 1608B3 and ask the court to order a method of service that is reasonably calculated to give actual notice. That is all that we are asking because if there is an order that says service on corporation service company is sufficient to serve PDVSA, PDVSA will be in a situation where there is an agent that can be served that cannot, consistent with U.S. sanctions, provide notice to PDVSA. PDVSA cannot, consistent with United States sanctions, appoint a new service agent, and yet notice on CSC will be deemed sufficient. You know, we might not find
Because this is going to cause some prejudice or harm to your client.
it'll cause harm to our client, and plaintiffs have other options. 1608B has.
So we should disregard what the agreement says and what was contracted for. We should disregard that based upon these new developments.
In these unique circumstances where the special arrangement is ineffective, and I would ask the court
You
to
have
look
time
at.
on rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Susan Adler for the respondent from the law offices of Robert M. Fox. What I wanted to point out is there's not actually a shred of evidence in the record as to why CSC stopped accepting service. We don't know that it's a political situation.
Right, I thought that there was some mention in the record is because they were not being compensated for their work, not that there was some type of governmental decree stating that they could no longer accept service.
That's what I was, that was what I was informed at one point. The letter itself from CSC gives about 6 different reasons, none of which are political or that they're unable to, just that they're not doing it. Now, CSC, service upon CSC absolutely would have complied with the FSIA because it was a special arrangement between the parties. It was contracted for.
Well, they rejected. Did they not reject service at some point in time?
CSC, yes, they rejected it. We don't really know why because the letter was a blanket letter. Now, part of the problem also here is that the agreement provides that if the agent is no longer accepting process, that somebody be promptly appointed to accept service in New York County. This was not done.
Well,
Now,
I think your friend stated that they, and I was not really clear why, that they're somehow precluded from now authorizing another agent.
That may be, but there's no evidence in the record or actual citation to anything that, that verifies that.
So am I understanding your adversary correctly? Mm, does, is there a need for a court to issue a ruling saying that CSC is authorized to accept service on behalf of Petróleos de Venezuela? Um, because the issue of payment doesn't seem to have anything to do with that.
I don't think it does, and what happened in both, in the lower court case as well as the federal cases that I've cited to involving the same, defendant, service on CSC was held to be effective service under, after the fact. So there already are court rulings, and what I wanted to point out is, yes, it may, be, put appellant into the position of having to accept service through CSC where they're not going to require notice. But this is the flip side of this, is that allowing a party to just allow the agency relationship to lapse pretty much opens up the door for other defendants and potential defendants to do the same thing.
Well, I think your friend stated under these unique circumstances, which I thought were political, but were not really fleshed out.
Yes, it's not actually in the record, and I don't have any information as to whether it was actually political. It could have been non-payment. It could have been. It could even have been that somebody unknowns to this particular appellant wrote a letter terminating the agency. The fact is we don't know that.
Thank you.
Your Honors, I want to point out that in the record at page 75 and on our brief at pages 9 and 10, we point to the sanctions that were imposed in 2019 that prohibit any company from transacting business with PDVSA, which would have prevented CSC from making service, or really from having any contact with PDVSA after 2019, including in 2022, when plaintiffs attempted service. And in terms of appointing a new agent,
Wouldn't that, since you had a contract with plaintiff that permitted service by CSC, if there were political events that occurred that made that infeasible, wouldn't the burden be on you to advise plaintiff of how they could notify you in the event of some incident?
Your Honor, our client had no idea that plaintiff existed because our client has no access to any of the records that are in the possession of the Maduro government, which issued this debt. Our client did not know about this note agreement, did not know about the plaintiff until 2022 when it found out about this lawsuit. So our client is incredibly uniquely situated here, and this goes to the point about appointing a new agent. And we do explain this on page 29 of our brief and include references to the OFAC regulations, which is that OFAC will not, the Office of Foreign Assets Control, we need to have a license to appoint a new service agent through the Office of Foreign Assets Control. And the Office of Foreign Assets Control will do diligence before providing PDVSA any new license. And the Ad Hoc Board of PDVSA, who we represent, that is the only representative of PDVSA that is authorized to operate in the United States, does not have access to any records regarding debt issued by the Maduro government.
So they have no information or no knowledge of any of these contracts, these guarantees?
That's correct, Your Honor. That's correct. So we're extremely uniquely situated. And so there's no way that the OFAC diligence could be completed because to appoint a new service agent under this contract, we don't even know what the contract is beyond what's been filed in the lawsuit. So in this unique situation where the existing service agent cannot serve PDVSA due to...
You want alternate service, but it seems that even with alternate service, you would not be able to defend because you have no information. So why are we going through why go through the steps of alternate service when you've already been served when you're stating you wouldn't even be able to defend because you have no information and you don't know what's going on. And you have no records, you have nothing.
Well, that is the unique position when you have a democratically elected government in exile, and it's foreign instrumentalities that are appointed by that government also in exile. But what the ad hoc board of PDVSA has done in these cases is that we take discovery and we determine the ad hoc board of PDVSA has a duty to PDVSA to make sure that its interests are defended in these United States lawsuits, because PDVSA, the ad hoc board, is the only representative of PDVSA that is authorized to defend these lawsuits in the United States. So we take discovery, we determine whether there are defenses, and represent PDVSA's interests in the lawsuit. That is how we have to operate because of these very unique situations, the very unique political situation.
Thank you so
in which
much.
Thank you, Your
both.
Honors.
People v. Christian Saunders. Yes, you may proceed.
Thank you. Good afternoon. May it please the court, Ben Schatz for Mr. Saunders. The negligent homicide verdict was against the weight of the evidence.
The criminally negligent homicide. So at any point in time during the trial, did the people present any theory that other than the accident was caused by the defendant's use of marijuana?
No.
Was there any theory that that was now set forth by the people that maybe he was exhausted or tired because he had gone from Soho back uptown and then back down to Soho? Was there anything in the record about his being exhausted or anything other than his use of marijuana?
No. There are bits and pieces of evidence where he says things like, I need to catch up on sleep, that kind of thing. Those utterances were not ever seen by the jury. The start to finish, the only issue in the case was he high? And the jury rejected that theory. And my client learned for the first time on appeal when I sent him respondent's brief that there was another theory about how tired he was, that he never...
That argument wasn't made in openings or closings by the people.
No.
And the judge's charge to the jury on criminal negligent homicide, did the judge mention anything in terms of any theory of the people other than that he was impaired, or even mention that?
No, the charge itself wasn't limited to a particular theory, but it's clear from the charge conference that everyone's in agreement that the theory of negligence is impairment by marijuana. Even the prosecutor suggested that impairment be charged first because all the other charges are built off of that charge. There was just no dispute that that was the focus of the trial. And the fact is that Mr. Saunders, who took the stand and testified in his own defense, had no idea he was being tried for the theory that the people are now offering.
And the charges relating to use of marijuana, those charges were, the jury acquitted on those charges?
Correct. If there are no other questions, I'll reserve for rebuttal.
Thank you.
Thank you.
May it please the court, Stephen Levy for the people. I think I might be able to respond kind of the 4 questions that you just raised, Your Honor.
Well, answer this question. Under what theory can you put forth, your theory of a case, and then when on appeal change that theory?
Yes, so the core issue here that I might be able to clarify for you is we are not deviating from the totality of the circumstances analysis that the jury was charged with.
But there's what totality of the circumstances? I mean, there's really one theory that you put forth throughout the whole trial, that he was impaired by marijuana, he was charged with other offenses involving that, and he was acquitted of those. And what theory now? Where did you find that in the record?
Sure, so 2 points, Your Honor. Let me respond first to what the
No, why don't you tell me where you found it in the record? Where is it in the record that you put forth this other theory?
So
Down below.
there is no argument in summation about exhaustion. The parties are in agreement on that. The argument focused on impairment and being high. but the actual evidence adduced at trial was not limited to being high. There was evidence of distraction. There was evidence of exhaustion as well, albeit.
But what
as we-
argument did you make as to any kind of impairment except by marijuana?
So the only argument for impairment, which again went directly to the vehicular manslaughter charge, that dealt solely with the issue of whether defendant was impaired.
By
Jury
marijuana?
correct, by marijuana. By contrast, the criminal neg homicide charge, that dealt with a totality of the circumstances analysis. So the jury's evidence
When did you argue, in what part of the trial did you argue that?
So the only time any
Totality of
argument.
the circumstances was in some way different from your argument of impairment by marijuana.
So, Your Honor, the scope of the charge here would be limited by the jury instructions. The jury was presented with evidence of exhaustion, of distraction, as well as strong evidence of being high.
I understand
Now,
that.
assuming.
At what point did trial counsel for the people argue that there was any argument, that there was any theory that didn't involve impairment by marijuana as a basis for the criminal charges?
There is no point at which we said impairment was not a basis, and in summation, that was the basis we emphasized. But assuming, of course, that there is some, it seems clear that there could be potentially, from my opponent, a factual inconsistency argument.
Okay, so the charge that was read to the jury by the judge was that with respect to the death, when that person engages in blameworthy conduct so serious that it creates or contributes to a substantial and unjustifiable risk that another person's death will occur, and when he fails to perceive that risk, and when that risk is of such a nature and degree that failure constitutes a gross deviation from the standard of care. In summation, and throughout, the prosecutor stated that it was clear that there was a cause for the defendant's driving behavior because he chose to smoke marijuana and drive. He was blameworthy, serious conduct because he knew that his actions, i.e. using marijuana and driving, could lead to traffic crashes that result in death. How does that play into the criminally negligent homicide?
So that is certainly the basis that was emphasized in summation for the criminal negligent homicide claim, but the people, because the jury instructions did not actually limit the theory, the jury was authorized, and we believe did in fact consider the totality of the circumstances.
And so what other circumstances? What other?
Yeah, so there's three fundamental ones. One, being high, which we stand by.
We're done with that.
Correct.
Move on.
Yeah. Number two, exhaustion, which we laid out in our brief extensively.
How did you show the exhaustion at trial?
The exhaustion evidence would have came from a few different sources. Some was the interview that was published to the jury, where defendant explained that he woke up at 3 a.m. on days he drove his truck. Then it was explained that he got home at 5:30 p.m.
So, and from that, the jury assumed that he was exhausted.
So the jury
Did anyone actually present that in that way to the jury?
No, Your Honor. The presentation did focus on marijuana impairment as well as distraction.
But was there anything in the record which would tie in that exhaustion to criminally negligent homicide in terms of a deviation?
Your Honor, you're asking whether—
I'm saying, you're saying that he was exhausted. Is there anything in the record that would tie that into the elements necessary to establish criminally negligent homicide?
Yes,
If
Your
I
Honor.
may just tack onto that, beyond a reasonable doubt.
Thank you.
Yeah. So the exhaustion evidence would have played into the evidence of being high and the evidence of being—
We don't want to continue to say being high, okay? Because we're taking that out of the equation.
Understood, Your Honor.
Okay. So we're just concerned with the exhaustion.
Yes.
And the perceived, and where did that come from in terms of exhaustion? Did the defendant or someone state that he was exhausted?
Yes, there's a text message where we cite this in our brief, where the defendant, upon waking up, texts Nikki, and he says to her, you know, I'm exhausted. I know in the reply brief, counsel had said this text was actually evidence that defendant was well rested because there was a statement he'd gone to sleep early.
Okay, so how does exhaustion then lead to, beyond a reasonable doubt, a failure to perceive that it constitutes, a failure to perceive that risk, and when that risk is of such a nature and degree that the failure constitutes a gross deviation from the standard of care?
Yes, so under Decina, exhaustion by itself and Enos, which we cite in our brief, could be a basis to find criminally negligent
Yeah,
homicide.
but you need to determine that the level of exhaustion. In both of those cases, there was testimony as to what that quote unquote exhaustion meant, or what it constituted.
Yes, in our position, again, is not a pure exhaustion theory. I know Your Honor said don't go into the evidence of
Well,
impairment
that was
or
only
high.
because of Justice Pittberg.
Fair enough. I should say as a fallback, if the argument fundamentally from the other side is this is a factually inconsistent verdict world where how did the jury convict of criminally negligent homicide but acquit of impairment offenses, you would then end up in the well-established, there could be jury compromise,
Oh,
mistake.
I
Yeah, yeah.
understand that, and I certainly agree with that. If there's something in the record which would somehow tie in that exhaustion or your other theories that you're now putting forth to the jury's determination of the charge.
Yes, I should also say, Your Honor, you are not limited to evidence that was expressly published to the jury as the 13th juror. And in fact, at 439.
Yeah, but you're not asking us to be the 13th juror. You're really asking us to be the sole juror here.
So, Your Honor.
And just to just accept this new theory that you have that the jury didn't even consider. That's what you're really asking from us.
And not only that, that any evidence of this exhaustion would therefore would therefore lead to his conviction of the criminally negligent homicide, and meaning that you prove that beyond a reasonable doubt.
Yes, but I do want to clarify again, our position is not any sort of purely exhaustion-based theory.
It's coupled with that.
Please don't say that again.
Right, it's coupled with
Listen.
right. Thank you.
Thank you.
I'm happy to answer any questions, but otherwise
I think we're good. Thank you so
thank
much.
you.
Thank you both. People v. Mark White.
Good afternoon, Nyla Siddiqui on behalf of Appellant Mark White. Mr. White had one small request, that he be given until the following morning to think about the most consequential decision of his life. For 4 years, he maintained his innocence. Then on the eve of trial, the prosecution for the first time made a plea offer. Your Honor, Mr. White is requesting that he be given until the following morning to make a final decision on this, to which the court tersely replied, well, I'm going to start with a hard no.
So our case law, we have a number of cases which state that it wasn't necessarily unreasonable for the court not to adhere to and give the defendant that additional time.
So in those cases, in all of those cases, there was always a plea offer made well before the trial date, and so the defendant always had time to consider the offer. For example,
so do we look to the fact that this was an extremely beneficial offer to the defendant? I mean, in this particular case, what was this was this rape? Sex abuse in the first degree. He was going to get 1 year city time. Should we not consider the seriousness of the crime, the fact that it was extremely beneficial to him, again, the 1 year city time, and also the fact that he had some familiarity with the criminal justice system and the way things work?
well, first of all, Mr. White had very limited experience with the criminal justice system. He had a 15-year-old B misdemeanor. He had never been to trial or been charged with a felony. Second of all, this was not a good deal. Even
1 year city time was not a good deal
The
for sex abuse in the first degree?
The court even stated during the Molyneux hearing that the defendant had a strong defense for everything the prosecution was trying to put forward. In fact, during the Molyneux ruling, when defense counsel highlighted the issues with the complainant, that she lied to the investigating officer at the time of the incident, that she lied to the grand jury, that she did not in fact run after him, but instead remained at the place, and that this was all fabricated to cover up an allegation of infidelity against her fiancé. So this was not a strong case, and it was so weak that the prosecution took this extraordinary step on the eve of trial.
When the plea, when the plea offer was made, was it immediate? Take the plea right now, offer, take the plea? Was there any time in between that?
So what the record shows is that a plea offer was made during the lunch hour, and then they returned to court. The prosecution did not make it an exploding offer. It was their offer that they made during the lunch break. They went back to the court after lunch and asked for more time till the following morning. Jurors had not arrived. There was no delay, and no delay was even being caused.
Let's just stop the timeline 1 second. You're saying that the offer was made during lunchtime, right?
Yes.
So the defendant was represented by 2 attorneys, and his family was there to consult with.
Yes.
So wasn't there an opportunity to review the advantages and disadvantages of taking the plea?
So first, the Molyneux ruling significantly changed the landscape of the trial, and 1 hour is
Would you answer my question?
1 hour was simply not enough, and it's the court's obligation, in the first instance, to ensure that a plea taken is knowing, intelligent, and voluntary. And during which, at that moment when when an offer was made, he was not told that it would expire at a certain time, that he had to decide in that moment. An offer was conveyed. He needed more time. It is competent counsel asked for more time. There's no,
So again, as I stated previously, our case law does not say that it's unreasonable under the totality of the circumstances presented to deny that request. Also, we do have cases concerning what would be an adverse ruling, or what would be a ruling that is not, that may be adverse in terms of the Molyneux, that where such a ruling is made and then there's an offer and then there's a plea taken, that we don't consider that in terms of being coercive.
no. So what the ruling, in terms of the case law, all of the case law is consistent where it was more than an hour. In fact, there's case law where courts granted 3 days. There's case law where it's clear from the record that the court asked the defendant if they would like more time, and the defendant declined. There is no case with these set of facts where the defendant asked for more time and did not have time before. So in those cases, the defendants always had at least a month because an offer was made before the case was even being sent out for trial.
But again, it's under the circumstances, the totality of the circumstances. And as my colleague stated, the defendant had 2 attorneys and his family was present at the time.
Yeah, so he had
So
2 attorneys.
Would that not be sufficient time to discuss this with his attorneys as well as to discuss it with his family members?
No, because of the nature of the ruling.
What was the maximum that the defendant could have received?
25 years.
25, and it's getting a year city time.
Counsel, you keep focusing on there being 1 hour, but when the case was recalled, it was 3:20.
That's when the case was called on the calendar, and that's, but what is clear from the record is that the defense counsel said, we met with him over the lunch hour. When they returned to court, only 1 attorney was present. So if he had more, he did not have both attorneys, and he needed more time, and to consult with counsel to make this decision. So given the totality of the circumstances, his lack of experience, the weakness of the prosecution's case, and that he was not given more time. Had this offer been made back in June when the Huntley-Dunaway hearing was held, that would be a different fact to consider. But he was given the
Do we know what the prior offer was?
There was never an offer made. There was never an offer made. There were no plea negotiations in this case.
The prior experience, you said no prior experience?
He had one 15-year-old B misdemeanor. He did not.
Attempted criminal contempt too, and then the stalking and...
There's no stalking conviction.
Pardon?
There's no stalking conviction.
Only the
There's
criminal
only
attempted?
there's only an attempted, and there's a public urination summons. But other than that, And it's a 15-year-old from the time of his plea. So he's never been charged with a felony. He had never even understood that the prosecution could introduce evidence of two witnesses, one who did not even state a date on which the allegations occurred. There was no DNA with the Molyneux witnesses.
Counsel, this occurred in 2019. He completed his sentence, right?
Yeah, he completed his sentence at the time he took the plea.
Right, it was almost time served.
It was effectively time served, but again, given
No,
the
I understand.
weakness
I
of
just
the-
wanted to be clear. I understand your point.
It's not just a sentence, it's lifetime registration for someone who maintains their innocence.
I know. Thank you.
Good afternoon, Your Honors. May it please the court. Andrew Kim for the people. I do want to clear up the record a little bit, Your Honors. I first want to point out that while this wasn't part of the plea colloquy or the pretrial proceeding, the defendant was arrested and charged with felony charges before. In fact, there were 3 total times where he was arrested and charged with felony crimes. One of them ended up in a guilty plea of the B misdemeanor, which my colleague has mentioned, and there were 2 other instances where he pled guilty to violations of harassment, the DV
This is the
harassment
first time that he's pleading guilty to a felony, and as your friend just stated, we're talking about registration.
Yes, that's correct, Your Honor. This was the first time he would be pleading guilty to a felony charge.
And this was the first time the offer was made over lunch?
That's correct, Your Honor. The offer was made for the first time over lunch. I do want to touch on that a little bit. The record is clear that the discussions with the defendant about the people's offer was not limited to 1 hour. The court was made aware that defendant was very seriously discussing the people's offer with his family members and his 2 defense attorneys, and counsel at one point confirmed with the court that he was in fact with the defendant, his family members, and his other defense attorney over the lunch break and after the lunch break. In fact, the court starts, when the court resumes at 3:20, the court starts by saying, "I didn't expect to see you at this hour," which suggests that it was the parties, presumably the defense, that reached out to the court saying, "Your Honor, we may have a disposition here."
At the point where the offer is made, is the defendant being held, or has he is he incarcerated or not?
He was incarcerated. He was brought to court, Your Honor, but by pleading guilty, he was sentenced the same day, and he was effectively receiving.
No, I understand. I'm just trying to figure out the access issue about lunchtime. That's all.
I see, Your Honor. I think the record is clear that the opportunity was there for the defendant to speak with his attorneys and his family members. And this really boils down to, I believe, what Your Honor was mentioning about the totality of the circumstances. It's not so much about how much time the defendant had to go over a plea offer. It's really about
that is kind of important,
It is
right? You don't want to be in a situation where someone feels coerced. I think that's the word that's being used, that they have to take this plea at this particular moment, especially when it's the first time that they're hearing it, and it happened over a lunch break, and a one-day adjournment might not be so unreasonable.
Absolutely, Your Honor. It may not be unreasonable, but the fact that it didn't happen here didn't make the plea coercive, particularly on this record where where there were multiple assurances given to the trial court from both the defendant and the defense attorney that the defendant was certain about his choice to plead guilty. And if I may just highlight one moment.
That's it. Thank you so much.
Thank you, Your Honor.
Very quickly, with respect to arrest charges, he may have been arrested on a felony, but it was never indicted. That's not what his rap sheet shows. And then with respect to defense calling the court saying we may have a disposition, the record is very clear. The first thing defense counsel said on the record is my client would like more time. And that is different from all of this court's cases where the first thing someone said on the record was my client wants to take a plea or would like to take a plea. That did not happen here. It is with respect to the court's statement that he had all of this time, that is belied by the record. That is stated after the attorney had said, we had the lunchtime to go over it, and then still the first thing the attorney said is, we would like more time.
How did the Molyneux ruling earlier that day complicate your client's consideration of whether to take the plea?
Well, first of all, understanding that these two women who he does not know, who there's no DNA, there's no identification procedure, this now implicates his right to not testify. He has a case where there's one complainant, a clear defense of consent. Now he has to now he may have to testify to say he either doesn't know these two women, they were still in the process of turning over the discovery in Rosario. And I would just like to note that the 2020 discovery reforms require prosecutors to turn over their application 15 days in advance in the trial, acknowledging that these evidentiary rulings do have a significant impact. This is a conversation to have with his defense counsel on his right to testify, how the trial is going to look now that there's two additional witnesses that no one knew about until that day, as well as his prospects on potential appeal if there is a conviction.
Thank you. Thank you both. Last case for argument is Domagioni v. Corpin, LLC.
Good afternoon, Your Honors. Richard Sabatini for the defendant Schindler Elevator Corporation. Your Honors, with me today is Schindler's National Counsel, Mr. Kevin Schifferl, and we ask and we make a request that he be allowed to make the argument today.
Yes, granted.
Thank you.
May it please the court. My name is Kevin Schifferl from Frost Brown Todd on behalf of Schindler Elevator Corporation in this, frankly, too long-lived case dating back to 2011. This court should reverse the denial of the summary judgment that Schindler rightfully filed based upon sound evidence.
Counsel, why isn't this a case of conflicting experts let it go to trial?
Great, that's a great question. Sometimes you do have battles of the experts, right? And that's certainly what the trial court wrote in the order. The problem with that is, Your Honor, is that you have to have an underlying basis of fact to make an opinion. In this case, we had an affidavit from our expert, Mr. Halpern, 38-year-old, 38 years in the industry, engineer who described how the escalators operate or don't operate.
But he used equivocal language. He said highly unlikely. He didn't say impossible.
Well, we know it.
No, I mean, isn't that a problem?
I don't believe it is. The language, and the reason it's not is the counter language that's used by the opposition.
Counter language is also problematic.
Yep.
The PE for the plaintiff, Mr. Karajat, I don't know.
Karajat, yes.
Was more probable that the escalator was shaking and caused by the Schindler mechanics, either by improperly restarting the escalator or jogging it.
Which is astounding. And the reason that I want to go back to the facts, because facts matter, are that the escalator that Mr. Krasnicki claims to have fallen down or did fall down was stopped. It was a stairwell. It was not in operation. It is turned off. It is not powered.
The problem that we
I'm sorry, go ahead.
the problem that we have is that Mr. Moroni, the Kmart services troubleshooter, said that he could not recall whether he worked on the handrail or on the step chain that was part of the subject escalator that day.
And also plaintiff's expert did state that there was even though the escalator was stopped, that if other things were occurring, they were trying to start it, or if the key was placed in or something of that nature, it could cause it to shake. It could cause it to suddenly start shaking, which comported with plaintiff's testimony as to what occurred.
Mr. Carriger said in that affidavit a lot of things, and he says a lot of things when I'm with him in court. The problem is they're not based on facts. And the fact is, undisputed, even the plaintiffs acknowledge this in their brief, the escalator was off. There was no work going on escalator 4.
We know it was
There was
off,
work.
but the testimony also was that if the adjacent elevator was jogged, I think was the phrase, by the people working on it, that could affect the non-working elevator. Doesn't that create a question of fact?
That it either by attempting to improperly restart the escalator or jogging the escalator,
Right.
a common occurrence when work is being performed on a stopped escalator, which would cause the escalator to shake.
The point being is escalator 3, which was being worked on, is not in any way, shape, or form tied to escalator 4. They are separate ectoskeletons, separate machines, separate operations. And what Mr. Carriger said, two things. He's saying, well, either the mechanics restarted this, which is remarkable for him to state because there's no facts of that whatsoever. And in fact, the testimony from Mr. Krasnicki himself, who used this stairwell, was, I looked, I saw other people using this stairwell, I waited, I then went and was on it when he says it began shaking violently. So to buy Mr. Carriger's theory, somewhere in the 10 steps he went down, some technician would have had to go and turn a key on the stopped elevator number 4A, or B, jogged that stopped elevator. There was
Why is that implausible?
Pardon me? Because
Why would that be implausible that his luck, that just when he's walking down the stopped escalator steps, that's when they decided they're going to do something with the other escalator?
It's implausible for two reasons. One, there was no work going on elevator number 4. Number two, and it's in the record, this is all on videotape. There's 23 minutes of videotape of Mr. Krasnicki at the store. Mr. Krasnicki fell down a stopped escalator with no movement on it whatsoever. Afterwards, Kevin McCarthy from Kmart did an inspection of the escalator and found that it was still off. So it's off before and it's off after.
Well, it was off but that was after the accident had happened. The person who came to inspect wasn't actually there when the incident took place.
I think you're confused. Two people.
Am I
I'm
mixing
sorry,
them up?
I know my time's up, but there is Mr. McCarthy who
Yes.
did inspect, who is the Kmart security guard. We're talking about Kmart. That's how old this case is.
I know, I was going to say,
And
Kmart's
then
been out of
the
business.
other person I believe Your Honor's talking about is Mr. Mulrooney, who is the technician for my client Schindler.
Now,
And
you
they both-
mentioned the video. Is there any video that shows the incident that does not show the escalator shaking in any way?
Well, it doesn't show that,
Right.
correct.
I didn't think so. Thank you.
I'll reserve.
So in essence, it seems to be the battle of not too great experts, because your expert really can't say conclusively, that it could have, the escalator could have shaken under those circumstances.
Your Honor,
definitively.
you're absolutely correct. I think neither of these experts is all that much of an expert, to be honest with you. I've run across both Halpern and Karajat before, and in my humble opinion, they are what is unpolitically correctly referred to as hired gun experts. They say whatever the party that hired them wants them to say. But
Why they use language like highly likable, like
probably,
probably.
but
That's still not language for which we can grant.
that was facetious on my part by saying probably.
But my point is that that's not language for which we can grant summary judgment.
Correct, and I agree with you wholeheartedly. But I'm sorry, I'm extremely. I guess you might notice I'm a little bit shaky right now.
Did you want to sit? Well, you could sit.
If I sit, I'll be in worse shape than if I stand
Okay.
right now. I just want to
Then
be
you don't
very
have to use all
quick.
your- you don't
I don't
have
want to
use
take
all
my
your
whole
time
5
then.
minutes.
You can use less time.
I'm going to use less time. I just want to point out that 2 weeks prior to this incident, on this very same escalator, the escalator was called in a priority one. I'm sorry, I'm so shaky, I can't even find the pages in here.
Again, if you want to sit down, you can certainly do so.
Here, it's pages 994 to 995. A code 1 priority call came in because this escalator was not working and would not restart. And then magically it started on its own, and their own technician and their own record shows that when he arrived, the escalator had started on its own and was running. So this is a situation where this is a res ipsa loquitur circumstance. This is a circumstance where the controls of this escalator, which I might point out was 40 years old at the time of the accident. It's like they were driving a car that was made 40 years
There was
earlier.
also an issue as to Schindler's records, repair records, for maintenance records and repair records for the escalator.
Yes, there's their own deponents went through those records in great detail. It's all through my brief. And they point out that they don't recognize some of the codes. They don't know what some of the references are. They know that some of the codes could cause an elevator to start or stop, or could cause an elevator to shake, but they don't know what a lot of them are, including on the day of the incident. Both witnesses who were working on the escalator that day testified they don't remember what they were doing. They don't remember what they were doing at the time of the incident. They don't.
Well,
so there's a lot of lack of recollection, which goes
the part that's questionable.
Right, and that
the employees, the elevator mechanics are not aware of what they were doing.
Correct, and
Would
and this
normally have
court-
to log everything that they're doing.
This court, in cases like Corella versus New York City Transit Authority and Stimmel versus Oshiro, has held that when the witness who is doing the work doesn't remember the exact work that was being done on that day or at that time, they haven't made out a prima facie that they did not create the condition, and so it has to be denied, which, by the way, was the first reason that Justice Kalish denied summary judgment. And again, thank you so much for your patience with my rather
not a
shaky
problem.
performance today.
It's fine.
I've had a couple of back surgeries. I'm kind of shot right now.
Just for the last ending here, several of you have focused on records, Your Honors. I believe that this is another area that's conflating things that have nothing to do with the issue of Elevator 4, which was
Escalator.
off. Escalator 4, which was off at the time and being used as a staircase. Questioning of witnesses who are working on Elevator 3 as to what work they were doing on Elevator 3, and then saying, you know, I don't recall this. Or I can tell you, the evidence is plain in this case, that when Mr. Krasnicki did fall, Mr. Mulrooney heard it, and he was there. The other employee, Francis Jr. or Frank Jr., he was back getting other parts. So what he was doing or how he was doing it has nothing to do with the operation of Escalator 4, because Escalator 4 was not in operation. So if we throw and
Did
conflate...
either one say, I didn't touch escalator 4?
Pardon me?
Did either one of them say, I didn't touch escalator 4, or did they say, I don't know if I did?
No, well, they didn't say either, because what they said is Escalator 4 was off, it had no power. And what's happened is Mr. Carriger proffered up an affidavit as a purported expert. He's not an engineer. I will take great exception to putting Mr. Carriger in with someone who's a professional engineer licensed in the state of New York, like Mr. Halpern. But what the fact of the case is that in this instance, with regard to Escalator 4, it was off, and it can only be turned back on by other means. And so for those reasons, we believe it's inappropriate to have an affidavit, because to your question, that what Mr. Carriger did, he set up a straw man. We put in evidence that the escalator was off, no power, that no one had touched it, that Mr. Kevin McCarthy, who's not our employee...
Who said no one had touched it?
It was off. The testimony was they turned the key...
Okay, so...
Okay, so the straw man argument is then, well, you didn't tell us that you didn't turn the key back on. That's what you're getting to, and the point of that is that's not part of a prima facie case to misprove a straw man argument that some expert comes in with speculation that someone did that you have to anticipate and say, well, we told you it was off, and by off we mean it was off, and by off we mean we didn't touch it, and by off we mean we didn't go get a key made, and by off we didn't do those things. That's the problem with the straw man argument by someone by a straw man argument by someone like Mr. Halpern who comes in without any facts and says anything and says, well, it could have been this. It
Thank
could
you
have
so
been
much.
this.
Thank you.